morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has not been sworn.
All right, please raise your right hand to be sworn.
Do you swear to translate from English to Spanish, Spanish to English, the testimonies you will receive today?
Yes, I do, to the best of my abilities, Laura Bretaña, Spanish interpreter.
All right, thank you. Please connect with the headset.
Sí.
There is contact, Your Honor.
Thank you. Good morning, sir. Please tell me your name.
Corbari Rojas. Corbari Rojas.
Corbari Rojas.
You're here in 21 MM 7080. A warrant was issued for your arrest, charging you with battery, domestic violence, and assault, domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you in this case. Your bond is $1,000 on count 1, $500 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Sí.
Yes.
You can't possess a weapon, firearm, or ammunition. You can't return to the victim's residence for any reason or be within 1,000 feet of her residence or place of employment. Are there any other conditions the state would request?
No, Your Honor.
All right. Good luck, sir.
Gracias.
Thank you.
Good morning, ma'am. Please tell me your name.
Priscila Rincón, juez.
Priscilla Rincon.
I believe we have a witness who also needs the interpreter. If you could please disconnect from the headset.
Necesito mi...
All right, ma'am, you're here in 21 MM 7777, charged with battery, domestic violence. At this time, I'll appoint an attorney to represent you in this case.
Señor, usted se encuentra aquí en la acusación 2021 MM 7777. Se le acusa de agresión física por violencia doméstica. Se designa un abogado de oficio para que les represente.
There is probable cause.
Existen indicios de criminalidad.
Let me ask you, sir, do you wish to be heard this morning?
Señor, permítame preguntarle, ¿desea usted expresarse esta mañana?
Sí, honorable. Quisiera solicitar al honorable la
All right, sir,
libertad.
before you say anything else, I need to have you sworn in.
Señor, un momento, por favor. Antes de que diga algo más, necesito que tome juramento. Yes, Your Honor, I would like to.
Oh, go ahead. All right, please raise your right hand.
Por favor, levante la mano derecha.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Ayude.
Y promete decir la verdad, solamente la verdad y nada más que la verdad.
Sí, prometo.
Yes, I do.
All right, thank you.
Please state your name for the record.
Muy bien, gracias.
Please state your name for the record.
Por favor, diga su nombre para que conste en actas.
Simón Patarroyo.
Simón Patarroyo.
Go ahead, Miss May.
Licenciada, proceda.
Good morning, sir. Can you please state your relationship to Miss Rincon Juez?
Señor, por favor, ¿podría decir usted qué relación tiene con la señora Rincón?
Es mi esposa.
She is my wife.
Are you afraid of her?
¿Usted le teme?
No, señora.
No, ma'am.
Has anything like this ever happened before?
¿Algo como esto había ocurrido anteriormente?
No exactamente en esos, como ahora.
Not exactly like this time.
Can you explain what you mean by that?
¿Podría explicar qué quiere decir usted con eso?
El choque nervioso de ella fue un poquito más fuerte esta vez, pero yo no quiero presentar cargos.
The nervous attack she had this time was a bit stronger, but I do not want to press charges.
Are you willing to call 911 if anything like this or anything more severe ever occurred in the future?
Si algo como esto volviese a ocurrir o volviese a ocurrir algo más severo, ¿llamaría usted al 911?
Yo estoy muy seguro que eso no va a volver a suceder, honorable.
I'm sure that this won't happen again, Your Honor.
Sir, my question is, if anything like this ever did happen, would you feel comfortable calling 911?
Pero señor, la pregunta que yo le hice es que si algo como esto volviese a ocurrir, si usted llamaría al 911.
Sí o no. Sí, señora.
I'm sorry, Your Honor, I'm going to have to ask him to repeat. Señor, por favor, repita la contestación.
Sí, lo normal, sí llamaría si fuera necesario de las autoridades.
Yes, if necessary, I would call the police.
Do you believe drugs or alcohol were involved in this incident?
¿Usted cree que las drogas o el alcohol tuvieron algo que ver en este incidente?
No, señora.
No, ma'am.
And do you want to have contact with Ms. Rincon while this case is pending?
¿Y usted desea tener contacto con la señora Rincón mientras el caso está abierto?
Si ella está de acuerdo, yo no tengo inconveniente. Ella es mi esposa.
Yes, if she agrees to it, I won't oppose it. She is my wife.
All right, thank you. That's all I have, sir.
Gracias, esas son todas las preguntas que tengo, señor.
Mr. Brands?
No questions. Your Honor.
Licenciado,
No questions, Your Honor.
no tengo preguntas, su señoría.
All right, thank you, sir. Ma'am, at this time, your bond is $500.
Gracias, señor. Señora, la fianza son $500.
With special conditions, you can have no contact with the victim.
Con la condición especial que se le prohíbe todo tipo de contacto con la víctima.
Do you understand what no contact means?
¿Entiende usted lo que significa prohibición total de contacto?
Sí, acabo de leerlo, no puedo llamarlo, no puedo nada.
Yes,
Es
I
que
just
no
read it.
entiendo,
Señora, permítame. Yes, I just read it. I cannot call him nor anything.
That's correct.
Proceda. Eso es correcto.
You can't possess a weapon, firearm, or ammunition.
También se le prohíbe la tenencia de todo tipo de armas, armas de fuego y municiones.
You must maintain a separate residence, and I will allow you to return one time with law enforcement to gather your belongings.
Se le prohíbe la convivencia y se le permitirá regresar en una ocasión acompañada de las autoridades para recoger sus pertenencias.
Do you understand?
¿Eso lo entiende?
No, o sea, no puedo volver a esa casa.
No, so then I am not able to go back to that house.
If he lives there, you cannot. I'm ordering that you must maintain a separate residence.
Si él vive allí, usted no podrá regresar. Estoy ordenando que se prohíba la convivencia entre ustedes.
At this time, you can have no contact with him, so you can't live in the same house.
Por este momento se prohíbe el contacto entre ustedes, así que no pueden vivir en la misma casa.
All right, good luck, ma'am. Thank you, sir. Good luck.
Thank you. ma'am.
Buena suerte, señora. Gracias, señor. Buena suerte.
Oh, does she have a hold?
No, it's just
No.
her fingerprint.
Okay. We'll try the headset again. Ma'am, please tell me your name.
Valeria Marie Torres Semide.
Do you not need a Spanish interpreter?
I do not.
Okay. Do we have any other interpreter cases after her?
Huh?
No, is she the last one?
I mean,
All right, that's all we need from the interpreter this morning. Oh, wait, is there anyone out in the gallery, any witnesses that need the interpreter? No? Okay, thank you.
Thank you, Your Honor.
All right, ma'am, you're here in 21 MM 7788, charged with battery, domestic violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
I do.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You must comply with any plan set in place by DCF.
However, question, how long is this no contact order for?
Until another judge changes it. So you can't have any contact with him until another judge allows you to have contact.
He gets to stay at my house?
Well, I'm ordering you maintain a separate residence.
Okay.
I don't have jurisdiction to order him to leave. I only have jurisdiction over you. So if he's there, you can't be there. But if he leaves, you can go back.
All of this started it because he find out that I called to remove the family petition. So he's trying to obtain a U visa.
Ma'am, all I can tell you is, according to the probable cause affidavit that I reviewed this morning, there is probable cause that you committed battery domestic violence. Now, if you have some defenses to this, or if there's other information that maybe wasn't contained in that
He's also
affidavit.
getting charged.
I'm sorry?
I see on the paper he's also getting charged with domestic battery.
Yes.
So who gets to stay at the house?
Okay, so once again, I'm ordering you to maintain a separate residence. If he appears before me, then I'll have jurisdiction over him as well as you. But I'm not going to tell you who gets to stay at the house. I'm going to tell you you can't live together. So call the number on that green piece of paper and talk to your attorney about the best way to work that out. But you two can't have any contact and you can't live in the same residence as him. Do you understand that?
Where do I sign?
You can't possess a weapon, firearm, or ammunition. You must comply with any plans set in place by DCF. Any other conditions the state would request?
No, Your Honor.
All right.
Right here?
Good morning, sir. Please tell me your name. Come on up.
My name Cordero.
Cordero what?
Dimby.
All right, sir, you're here in 21 MO 1259, charged with stealing passage to an amusement park. Was the public defender appointed yesterday? All right, Mr. Brands, I am going to appoint your office in this case.
Yeah, we did have an offer, withhold credit time served, and I did communicate that offer to Mr. Demby, as well as a plea form to review. I believe he wishes to resolve today.
All right, raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes.
All right, sir, you can put your hand down now. There is probable cause here. I reviewed the affidavit. You had an opportunity to discuss with your attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about them?
No.
You understand that if you're on probation anywhere, this plea could violate that?
Yes.
You understand if you're not a U.S. citizen, you could be deported?
Yes.
And I don't know, sir, if you are on probation, but I see that you have some convictions for out-of-state offenses. So what this means is, even if you're on probation in another state and you enter a plea of guilty or no contest this morning, that could potentially cause a violation of probation. You understand?
Yes.
All right. Did you have an opportunity to review that form in front of you? It further explains these rights to you.
Yes.
All right, sir, at this time, how do you wish to plead to the charge of stealing passage to an amusement park?
Guilty.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 3 days? 3 days you've been in custody, sir. I have to order that you pay court costs. I'll give you a year to do that. And I'll order that you're not allowed to return to, is it Volcano Bay?
Yes, Your Honor.
I just closed it out. All right, sir, you can't go back there. You understand?
Yes.
Good luck, sir. You have 30 days to appeal in writing. 21MM7757. I'm going to appoint your office, Mr. Brantz.
We'll waive the appearance, Your Honor.
All right. There is probable cause. His bond is $500. He's not allowed to return. I'm going to revoke his bond in 20 CF 7790.
Your Honor, can I approach?
Yes.
We did have one that I believe wasn't going to be heard today. I don't know if he bonded. Is someone mind confirming?
Thank you.
Mr. Crawford
Yes, he bonded.
bonded. Thank you.
Please tell me your name.
Jada Barrett.
21 CF 14287. You're here charged with aggravated battery, domestic violence. I'm going to appoint an attorney to represent you in this case. Do we have the other one wasn't charged? She wasn't arrested, right?
I believe it was just a file, Your Honor. Yeah.
Okay, so they're contacting the state attorney's office about that? Okay. I just wanted to make sure if we needed to bring them both in at the same time.
I don't believe so, Your Honor.
Can the state tell me what's aggravated about the battery?
I believe it was the use of a weapon, Your Honor. It was a
Okay.
candle or several candles, arguably.
It is that. That is there. Okay. All right, ma'am. There is probable cause. Does the state object to pretrial release?
No, Your Honor. State would just ask for bond with pretrial release and pursuant to the statute.
I'll do that. Your bond, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount significantly. So your bond on this will be $500 with pretrial release. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess a weapon of any kind, firearm or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck. Please tell me your name.
Darius Donald.
All right. A warrant was issued for your arrest in 21 CF 14089, charging you with domestic battery by strangulation, false imprisonment, and battery domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you in this case. Good morning, ma'am. Did you wish to testify this morning?
I would like to speak.
All right, raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, self you God?
Yes, ma'am.
Please state your name for the record and spell your last name.
Latoya Richards.
Go ahead, Ms. May.
Good morning, Ms. Richards. Can you please state your relationship to Mr. Donald?
My husband.
Are you afraid of him?
No, ma'am.
Has anything like this ever happened before?
Not like this.
Have you ever had any arguments or disagreements that turned physical?
Not really.
Not what?
She said not really.
Not really.
Sorry, I couldn't hear.
Do you believe drugs or alcohol were involved in this incident?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes, ma'am.
And you want to have contact with him while this case is pending?
No, ma'am.
Was that a no?
No, ma'am. But I would like to drop all charges against him.
Okay.
So let me explain how this works. You can't actually do that. This is the state of Florida versus Darius Donald. He's being charged with committing a crime against the state of Florida. So the state is who's prosecuting him. It's not you versus him. So it's up to the state of Florida whether they're going to file the charges and whether they're going to pursue them. So you
Okay.
can contact the state attorney's office, but I think people misunderstand when they hear they want to drop charges, they think they can do that, and that's really not how it works in the state of Florida.
Okay.
Did you have any other questions, Ms. May?
No, Your Honor.
All right, anything from you, Mr. Brantz?
No questions, Your Honor.
All right.
Your Honor, when setting bonds, we just asked that you take into account his criminal history. 1 second. He recently had a 2017 non-arrest bat by strangulation DV and bat DV. Victim in that case being a different victim. He also had a 2015 misdemeanor non-arrest, bat DV, victim also being a different victim than the one present today, as well as a 2014 false imprisonment DV, bat DV, and criminal mischief, victim also being a different victim, a 2013 misdemeanor bat DV and BOP, victim in that case also being a different victim.
All right, thank you. Mr. Brantz, is there anything you want the court to consider?
Just straight bond on the charges, Your Honor.
All right, sir. At this time, your bond will be $5,000 on count 1, $15,000 on count 2, and $100 on count 3. With special conditions, you can have no contact with the victim or the witness in this case. Do you understand what no contact means? You have to answer out loud.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
How old is the niece? Do you have that?
I didn't make notes. Hold on 1 second, Your Honor. I don't believe the age of the niece is within the report, Your Honor.
Ma'am, how old is your niece?
She's 12.
She's 12?
Yes, ma'am.
All right, sir, you can have no contact with any minor child under the age of 18. You must comply with any plans set in place by DCF, if there is one. I don't know if there will be.
No, ma'am.
All right, good luck, sir. Thank you, ma'am. Good luck. Please tell me your name.
William Gray.
You're here because a warrant was issued for your arrest in 21 CF 14291, charging you with false imprisonment, domestic violence, domestic battery by strangulation, and battery domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Does this say he was released from DOC in 2019?
Yes, Your Honor.
For false imprisonment, felony battery?
Yes. In Hillsborough.
All right, sir, your bond will be $15,000 on count 1, $5,000 on count 2, $500 on count 3. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon, firearm, or ammunition. Were you living with this victim? All right, you can't be within 1,000 feet of her residence or place of employment. Any other conditions the state would request?
No, Your Honor.
All right. Please tell me your name.
Right.
A warrant was issued for your arrest in 21 CF 14209, charging you with possession of a firearm in the commission of a felony, aggravated assault with a deadly weapon, aggravated assault with a firearm, and battery dating violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Good morning. Do you wish to testify?
No.
All right, thank you. All right, give me one moment. Sir, at this time, I'll stay the bond at $5,000 on count 1, $5,000 on count 2. It'll be $10,000 on count 3 and $500 on count 4. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. That means any type of weapon. Do you understand? You can't be within 1,000 feet of the victim's residence or place of employment. Did I say no contact with any witness?
Yes, you did.
Yes, okay. I'm ordering that you must surrender all firearms and ammunition to law enforcement within 24 hours of your release. Any other conditions the state would request?
Not on this case, Your Honor.
At this time, I'm revoking your bonds in 21 CF 4039 and 21 CF 4046. Good luck, sir. Good luck, ma'am. Please tell me your name.
Sherry Singleton.
You're here in 21 CF 14116 because a warrant was issued for your arrest, charging you with aggravated assault with a weapon, domestic violence, and battery, domestic violence. A judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, state would just have you take into account her criminal history. It looks like she has at least several arrests of other violent offenses. However, according to the face sheet, it is against different victims. However, she does have a violent criminal history.
Mr. Brantz, anything from the defense?
She is entitled to a reasonable bond on these charges, Your Honor.
Ma'am, at this time, your bond is $5,000 on count 1, $500 on count 2. With special conditions, you can have no contact with any victim or witness in this case. Do you understand what no contact means? Ma'am? I'll give you a minute. All right, ma'am. Do you understand what no contact means? Ma'am, I need you to answer out loud.
Sorry.
Do you understand what no contact means?
Yes.
All right, you can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
I don't stay with them.
Oh, you don't live there?
No.
Okay, then I'll just say no, do not return to the scene. You can't have any unsupervised contact with any minor child under the age of 18. You must comply with any plan set in place by DCF. Are there any other conditions the state would request?
No, Your Honor.
Good luck, ma'am. Please tell me your name. 21 CF 14247. You're here charged with aggravated assault with a deadly weapon, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause here. Is this a charge that qualifies for mental health pretrial release?
I'm not too sure, Your Honor, but you can have them screened. I'm so sorry.
Okay. we all know the outcome of that, right? But it just seems like, given the facts here, that might be a really good option for your client.
There's really no criminal history,
No?
but
Well, there might be. It was expunged.
I would just have you set bond, Your Honor.
Your Honor, state would ask for him to be screened for mental health pretrial release. He told pretrial that he potentially has some mental health problems. The victim in the case said there potentially is some mental health problems, and when he's on medication, it potentially kind of levels out. I believe mental health pretrial release, if he was accepted into the program, would be a good option for him, and it looks like he fits the criteria.
Your Honor, the screening process takes a while, and we haven't seen a lot of success stories and clients meeting mental health pretrial release
Right.
acceptance, so I would just still have you set bond.
However, if he was accepted, doesn't that program provide some resources that might be helpful for your client?
Yeah, yes, Your Honor, but our office can also point him in the right direction as well without having him stay here to be screened. We have social services that work with clients all the time with mental health or homelessness issues or food and shelter issues.
Can I put him on pretrial release, Rebecca?
Yes.
All right, here's what I'm going to do. I'm going to order that he be screened for mental health pretrial release with a bond of $100. If he doesn't qualify for that, pretrial release with a bond of $100. So, sir, what that means is, instead of having to post a $5,000 monetary bond, I'm asking that you be screened for a program called pretrial release, and that program hopefully will have some resources, help point you in the right direction to get you some help. While you're out on pretrial release, sir, you can have no contact with the victim. Do you understand what no contact means?
Yes, but can I say something real?
You can say anything you want, but everything you say is being recorded and can be used against you later. I'm going to give you a minute to talk to your attorney first. All right, sir, let me interrupt for just a moment. Mr. Wilkin, I want to explain something to you. Today, all we're doing is establishing if there's probable cause and setting your bond conditions. I read the affidavit, so it may not be. I don't have a way to know everything that happened. I only know what's in the affidavit. You also might have some wonderful defenses in this case that you can talk to your attorney about, and I don't know if the state of Florida is going to file the charges. So today, we're just here because there is probable cause. That's all this is. But because there's probable cause, I do have to set bond conditions for you.
Your-
And, go ahead, Mr. Brands.
I'd just like to raise my argument against the mental health pretrial
Okay.
release, as it may take a while and he may not qualify at the end of an experience. So I believe pretrial release is sufficient enough to keep him in contact with the court, and as well as our office. As I suggested to him, our social services people can talk to him about alternative housing if that becomes an issue, and any kind of mental health or therapy that may be necessary as well.
Your Honor, respectfully, the PD's office has limited resources, and the social services have limited resources. Social services can still be in contact with him, even if he is on mental health pretrial release. That program was put in place for incidences like this, for defendants with limited criminal history. I understand defense's argument that he doesn't want him sitting here for the couple days that it takes to screen him. However, he does seem like a good candidate, and we won't know if he gets into it or not unless we screen more people for pretrial release.
I understand your argument, Ms. May, but respectfully, in the almost year that I've been here, we've had 3 people who get in the program? 2?
About 2.
None? I get it. We have this program. It sounds like a fantastic program. It should be a wonderful resource. I just haven't seen very many people get into it. So I understand your argument. I understand the defense argument. At this time, I'm going to grant your request, counselor. So I'll place him on pretrial release with the monetary bond. But sir, you can't have contact with the victim. Do you understand what no contact means? So you can't talk to her, you can't call her on the phone, you can't send a text message, you can't contact her on social media. You can't have any contact with her right now. Mr. Brantz,
And Your Honor,
is there a way to, all right, sir, I can't solve all of that today. All I can do is tell you that because of the charge, I can't allow you to have contact with her.
I understand that, but I was just protecting myself. My sister came at me with a baseball bat. What do you want me to do? They abuse me every freaking day. Every day they force me to do shit. I'm tired. I'm exhausted. I get no days off at work. I'm tired. They need help.
I believe you.
Therapy. I'm tired of them.
I believe you, sir, but I can't fix that either today. So here's what I'm gonna do.
What do you want me to do? They beat me, and then I stored anger and I let it out. I already have enough mental illness. I cannot control all this.
I believe you. I really do.
Look at her history. She got me taken away at the age of 6. I didn't get to meet her until 20. I should have never did it.
Listen, again, sir, I believe you, but I can't fix all of that today. Unfortunately, because of this charge,
I have no contact with my mother and my sister.
right, you
My
can't,
only family members here.
right, you can't right now. And you have to maintain a separate residence, but I'm gonna let you go back one time with law enforcement to gather your belongings.
That's a lot of stuff.
Right, you don't have to get everything. You have to get enough stuff to survive right now. So on that green piece of paper is a phone number for you to call your attorney.
She wants nothing.
They can give you all the advice you need about how to make this work the best way possible. Mr. Brantz also said they're going to try to point you in the direction of some resources that may help you. Listen, I understand what you're saying and I believe you, but unfortunately I can't fix it this morning. So what I need you to do is make sure that you comply with my court orders and call your attorney right away. Do you understand?
I don't even got one.
You do. I just appointed an attorney to represent you. So call that phone number and they'll tell you who's assigned to your case and they'll be able to help you. Also, sir, at this time, you can't possess any weapons, firearms, or ammunition.
I don't have no gun.
Okay, so that'll be easy. That'll be easy to comply with. So don't go buy one right now. You can't.
But I have them already, so I'm not allowed to have them no more.
I couldn't hear him. What?
the swords, Your Honor.
I have swords and all kinds of other stuff.
You say weapons include swords, Your Honor?
He has weapons in his storage?
He has swords.
I have
Oh, swords.
all my stuff is in my room. Like everything in my room.
Well,
As long
leave
as-
it in your room.
Leave it there.
When you go back with law enforcement, don't get any weapons because you can't possess them right now.
But I don't want to leave anything behind because they hate this shit.
All right, sir, so you can talk to your attorney about what to do. You can also surrender those to law enforcement for the time being, but you can't possess them. You can't take them with you.
All because I was protecting myself. I didn't even wait for that anymore. All I did was hold it like this from getting
PTR and a $100 bond. All right, good luck, sir. I need you to call your attorney, okay?
So you want me to strike the mental health PTR? Your Honor?
Yes. Please tell me your name.
Christina Barisi.
21MM529. You're here charged with battery. I'm going to appoint an attorney to represent you. There is probable cause here. Give me one moment. So I want to make sure I understand. Is she out on bond on a VOP or no?
Yes, she just bonded on that. Let me check.
I thought it indicated a notice to appear.
Yeah,
It says that.
it was a notice to appear for an upcoming hearing, but that case was already open prior.
So she had a bond on a violation of probation?
No, Your Honor, I didn't go to jail for that.
So you were never arrested on the, whatever the underlying offense was?
Yes, correct.
Okay, so I'm gonna take no action on that. Your bond on this is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, Your Honor, thank you.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
Thank you so much.
She was arrested on that on June 4th of 2021 for the underlying charge
June 4th?
of 2021.
So when did she bond out?
Didn't go to jail.
Wait, for the underlying offense or the VOP?
For the underlying offense.
Okay, so then she pled or went to trial on that, was sentenced to probation. Then there was a violation of probation. Yeah, I'm gonna take no action on that. All right, thank you. Good luck.
Thank you so much. Have a great day.
Your Honor, I'm sorry, I missed the bond amount.
500? Yes.
Thank you.
Please tell me your name.
Ralph Davila.
21MM7785. You're here charged with violating a condition of pretrial release on a domestic violence case. There is probable cause. I'll appoint an attorney to represent you. All right, Mr. Brands, your client has several violations of injunctions. I see one failure to appear, several violations of probation. It does not appear that there are any conditions this court can place on your client with which he'll comply.
Your Honor, in addition, the conditions in this case, he was arrested 10/20. Arguably, I believe he bonded 10/21. So it's been approximately 10 days before he violated this no contact order.
Your Honor, unless the state is filing a pretrial detention motion, Mr. Davila is entitled to bond on this charge. You can set conditions as part of his release that aren't included in a usual injunction. You can set a curfew. You can have him relinquish any and all weapons. You can have the defendant meet with a pretrial release supervisor and keep a schedule where they'll be similar to community control. But under the rules and the statute, he is entitled to bond on this charge, Your Honor.
Respectfully, Your Honor, that's not incredibly accurate. There are three ways someone can be held no bond: being a PBL or capital, being a violation of a court order or injunction, or any kind of court order that was put in place if the court cannot find reasonable means. And the court makes findings that there are no reasonable means given the history and the facts alleged. So Your Honor can find no bond
Your Honor, I believe the rule and the statute need to be read together, which would require a pretrial detention motion to hold someone no bond on this charge.
Who ordered the original no contact? Do you have that?
It was ordered by Judge Bain on 10/21, and he bonded 10/22, $1,500 bond.
All right. Well, I disagree with your reading of the statute and the rule, Mr. Brantz. We have this discussion over and over again.
Yes, Your Honor.
At this time, Mr. Davila, I am going to give you a bond, but I want to make sure that you understand exactly what I'm ordering today. When I say that you can have no contact with the victim in this case, do you understand what no contact means?
Sort of.
You cannot speak to him. You cannot send a text message. You cannot call him on the phone. You cannot go to his residence. So when Judge Bain ordered that you were not allowed to be within 500 feet of his residence, I don't think that was at all unclear, but you did it anyway. So I want to make sure that you understand at this time, when I say to you that you cannot be within 500 feet of your brother's residence, if you go within 500 feet of his residence again and get arrested, you will likely be held with no bond. Do you understand that?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. At this time, your bond is $100,000. Good luck, sir.
Sounds super high.
Please tell me your name.
Christina Lezin.
21MM7787. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. At this time, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Ma'am.
You can't possess a weapon, firearm, or ammunition. Were you living with this victim?
She was living with me.
All right, I'm going to order that you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
But if she's not there, I can stay, right?
Correct. Just you can't live together, but I don't have jurisdiction to order her to leave. All right, good luck, ma'am.
Your Honor, in regards to Mr. Davila, who just left, wouldn't he have been out on bond on that other case? Are you taking no action on it?
I didn't have that he's out on bond. Is he?
Yeah.
Hold on one second. We might have to bring him back in.
The underlying BAT DV that gave rise to the violation.
But I don't have it. I would have thought so, but I have nothing to indicate he's out on bond.
I have that the date of incident was 10/21. He was seen at IA on 10/21, and he bonded 10/22.
Do you know why we don't have that?
I don't know, but I don't have anything either, and there was no hold placed on him.
But you're right. Why isn't there?
There should have been like a little box, like normal.
But I mean, I don't even have, I don't have any notes in the clerk's file or anything. So
I'm looking at the normal clerk site, and that's where I got that he bonded, and the bond is active as of 10/22.
all right, we're gonna have to bring him back in because you are right. Do you have that case number?
21MM 7439. Sorry, I didn't catch it sooner.
Is it going to be a minute for him to come back? Because we can do her case. Okay. Let's address her case before he comes back. Please tell me your name.
Really, Maceo?
21MM7789. Ma'am, you're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must comply with any plan set in place by DCF. Are there any other conditions the state would request?
No, Your Honor.
Also, you can have no contact with the witnesses in this case. All right, good luck. Please tell me your name.
Fernando Ortiz.
21MM268. You're here charged with violating a condition of pretrial release in a domestic violence case. I'm going to appoint an attorney to represent you. There is probable cause in this case.
Your Honor,
Yes.
as to probable cause or to the argument that whether there was the victim in the no contact order at the residence, I believe a lot of the court's orders include a clause that if the person's not there, that they are free to return, especially if it's a shared residence. And I think this may be one of the circumstances where the person wasn't there. There were facts in the affidavit that the landlord had indicated that she was probably moving out and leaving. And I believe that's why Mr. Ortiz returned, because he knew that the alleged victim wasn't present.
However, the no contact order that they signed says they're not allowed within 500 feet.
Where is that in the no contact order, Mr. Brantz?
No,
You have the order?
what I was relying on was the court's oral clause that usually includes the idea that if the victim's not there, it's the same contact order they sign all the time, but a lot of times the court will say, if they're not there, you can go back, especially if it's a shared, they're both on the lease or they're both on the mortgage.
Your Honor.
I don't believe that's what I say, and I don't know if that's what Judge Bain says. But it says that the order says must not be within 500 feet of the victim's or other named person's residence, even if they share a residence. And even if the victims would like to have contact with you, you must not have contact with any victim until the court changes this no contact order in writing.
He also made a good faith attempt to get law enforcement to go over there with him, even though they kept declining.
Your Honor.
Just a second. Please. Can I have a moment?
I don't know that that was a good faith attempt, Mr.
Your Honor, that was
Brantz.
gonna
I
be
read the
state's
affidavit.
Argument about regarding this, whether this was a good faith attempt, given the third paragraph and how often the story changed.
Right.
My landlord that she was going at 9 a.m. yesterday morning, and I showed up at 10 o'clock or 11 o'clock last night, and called the police after I leave to check on the wall. And the house was okay, and I called them to report she had been there.
You can tell her that if you want.
Your Honor, I'm sorry, and I know I'm not supposed to speak.
Hold on. You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am. And what I want to say, I want to be recorded because I called the police to report my child taken out of state, which DCF told me she was not allowed to do. And she called at 9 a.m. saying that she had left for Tennessee and was gone from 9 a.m. I didn't get to the house till over 12 hours later. And when I did was to check on the dogs, my door was wide open and the dogs could have ran out. They didn't. But the house is cleaned out. She took everything. She left her keys and emptied the house with her brother from Tennessee. She's now 700 miles north illegally, from what I understand. And all I did was call the police to try and report that, okay? I wasn't trying to contact her. I called for a wellness check prior to my coming to the house. They said they wouldn't do it because it was them acting as a third party, and that's illegal, I guess. And so they said they wouldn't do it. My landlord then got a text message from her saying, I'm not coming back to the house. I'm in Tennessee with the baby. I've packed my things. I've left the key, and the dogs need to be taken care of. So my dogs were being neglected, and I just came home to make sure they were okay and then to report the kidnapping, essentially, her stealing my child and taking him across state lines. The DCF worker has not answered me, and I haven't gotten any cooperation with law enforcement as far as helping me with, trying to mediate or solve or figure out where she is and what she's doing.
All right, so law enforcement are not mediators.
Okay?
That's not what they do.
I understand.
They investigate crime, basically.
Yes, ma'am.
I understand what you're saying today. That's different than what's in the affidavit. Part of that is in the affidavit, but the reason that I said that there's probable cause to believe that you violated the conditions of pretrial release is your story to law enforcement changed multiple times, and then law enforcement showed up and found you at the residence, which now you're telling the court you were there.
No,
I understand that listen, let me finish, buddy. I understand that you're telling me that you have a defense to this. I do. You might have a really compelling defense. And I don't know what your fiance did and whether it's lawful or unlawful. It may be kidnapping. You might be right. But there is still probable cause to believe that you violated this court's order. However, Mr. Ortiz, you want to listen to what I'm saying. I do think that this is a very unusual case. And so I'm not going to revoke your bond in the battery case right now, which is unusual. What I'm going to do is I'm going to set your bond in this case at $1,000, which is also unusually low for me. You still can't have any contact with the victim. You can't possess any weapons, firearms, or ammunition. And on that green piece of paper is a phone number for the public defender's office. You'll have an assigned attorney. You want to call them right away because, listen, I believe you. I can't fix it, but I believe what you're telling me. So you want to talk to your attorney right away because if there are any defenses that you need to raise in this case, they need to communicate that to the state attorney's office. You understand?
Yes, ma'am.
All right, good luck, sir. Yes, sir. All right, tell me your name again, sir.
Ralph Davila.
All right, in 21 MM 7439, at this time, I'm going to revoke your bond in that case. So your attorney is going to have to file a motion in front of the trial judge to get your bond reinstated. Good luck, sir.
By the way, my brother's in jail, so
I read that.
he's downstairs.
Yeah, I know. I read that. Good luck. Please tell me your name.
Jason Santana.
21 MM 7786. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess any weapons, firearms, or ammunition. Are there any other conditions the state would request?
There was a child present, Your Honor.
I'll order you must comply with any plan set in place by DCF. All right, good luck, sir.
So much.
Please tell me your name.
Ellie Young.
21MM7780. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means? Even if you go back out of state, you can't live together. I'm ordering you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't return to Disney's Blizzard Beach Water Park. You can't possess a weapon, firearm, or ammunition. You must comply with any plan set in place by DCF. Any other conditions the state would request?
No, Your Honor.
Good luck. Please tell me your name.
Amir Muhammad.
It looks like you have a warrant out of Volusia County for burglary of an occupied conveyance and petty theft in 21-222-965. Your bond is $5,000 on count one, $1,000 on count two. I'm going to appoint an attorney to represent you and will notify Volusia County that you're here so they can transport you. At this time, I'll take no action on his out on bond case. Good luck, sir. Please tell me your name. Sir, you have a warrant out of Seminole County in 20 CF 28C4, 2834 CF. It looks like it's for possession of methamphetamine. There's no bond authorized on that warrant. I'll appoint an attorney to represent you and will notify them that you're here so they can transport you. Good luck, sir. Please tell me your name.
Justin Rodriguez.
Sir, it looks like you have two warrants out of Osceola County, 21 CF 3070 for grand theft, criminal mischief, burglary of a conveyance, and conspiracy to commit criminal mischief. Your bond is $1,000 on the grand theft, $2,500 on the criminal mischief, $1,000 on the burglary of a conveyance, $1,000 on the conspiracy. We'll notify Osceola County that you're here so they can transport you, and I'll appoint an attorney to represent you. And then in 21 CF 3054, you have a warrant for the same charges: grand theft, criminal mischief, burglary of a conveyance, criminal conspiracy. And your bonds are different. $2,500 on the grand theft, $1,000 on the criminal mischief, $2,500 on the burglary, and $500 on the conspiracy. Again, we'll notify them that you're here so they can transport you. No action on the out on bond case. Good luck. Please tell me your name. 21 CF 4601. You're here for violating probation. The allegations are that you committed the criminal offense of possession of cocaine on or about October 16th, that you committed the criminal offense of tampering with evidence, possession of drug paraphernalia, possession of marijuana under 20 grams, And see if there are any other conditions that alleges you violated. I believe that's the allegation. I'll appoint an attorney to represent you. You have no bond on that warrant at this time. Good luck, sir. Please tell me your name.
Rogelio Nuno.
20 CF 12845. You're here on a warrant for violating your probation. There's no bond on that. I'll appoint an attorney to represent you. Give me one moment, I'll tell you the allegations. The warrant alleges that you failed to undergo drug and alcohol evaluation as ordered. Failed to attend the STEPS program. All right, good luck. Yes, sir. Please tell me your name. I'm sorry? I don't have him.
I don't either.
What's the name?
Nope, I don't have him anywhere.
Your Honor, would you like the affidavit?
Well,
This says BOP warrant.
yeah, I mean, but I don't know why he's here. If he doesn't need to see a judge, I'm sorry they woke you up, but do you know why he's here, Mr. Brantz?
He bonded, Your Honor. It was a BOP, but he bonded.
Oh, he bonded.
Mhm.
Oh, well then, I'm sorry they woke you up, but you don't have to see me and you bonded out.
What was his bond?
It was ROR.
Oh. On a VOP?
Mhm.
All right, good luck, sir. Please tell me your name.
Alexander Tomaselli.
21 CF 3683. Sir, you're here for violating your probation. A warrant was issued that states that you left your county of residence without the permission of your probation officer, and that you committed the criminal offense of driving while license suspended, that you, I think those are the allegations. There's no bond authorized on this warrant, and I'll appoint an attorney to represent you. Good luck, sir. All right, Ms. May, is the state ready for?
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good morning. Please connect with a headset. Sir, can you tell me your name?
I'm asking if he can hear me, but he's not answering.
Yeah, it doesn't look like he can hear. Can you guys look at the
I'm gonna
headset?
disconnect and dial again just in case.
Okay, thank you.
He's not answering, Your Honor.
He doesn't hear it?
¿Usted me escucha?
I can't hear. No.
No? It was just working this morning.
Is there a volume on the sign?
No.
He's not answering.
All right, just take the headset off of him.
No.
All right, let's try it without. Sir, please tell me your name.
Señor, por favor, dígame su nombre.
Mauricio Manzanari.
Mauricio Manzanares.
Sí.
Sir, you're here for two cases. In 21 CT 520, a capias was issued for your arrest for failing to appear for court on a charge of no valid driver's license. The bond authorized on that capias is $2,000. I'll appoint an attorney to represent you.
Señor, usted se encuentra aquí, tiene dos acusaciones. La primera, una orden de arresto emitida bajo el caso 2021 CT 520 por falta de comparecencia ante una acusación de conducir sin licencia válida. La fianza son $2,000 y se designa al abogado de oficio para que les represente.
In 21 CF 14294, you're here charged with aggravated battery with a deadly weapon.
En cuanto al caso 21 CF 1429, se le acusa de agresión física agravada con arma letal.
There is probable cause.
Existen indicios de criminalidad.
I'll appoint an attorney to represent you.
Se designa al abogado de oficio para que les represente.
Your bond is $5,000.
La fianza son $5,000.
You can have no contact with the victim.
Se le prohíbe todo tipo de contacto con la víctima.
You can't possess a weapon of any kind, firearm, or ammunition.
Se le prohíbe la tenencia de todo tipo de armas, armas de fuego y municiones.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
Se le prohíbe la convivencia con la víctima. Se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
Any other conditions the state would request in that case?
¿La fiscalía desea solicitar alguna otra condición?
Yes, Your Honor. State also requests no contact with the witness, Carlos Alvarado.
Sí, su señoría, la fiscalía solicita que también se le prohíba el contacto con el testigo Carlos Alvarado.
I will order that you can have no contact with the witness.
Señor, se le prohíbe tener todo tipo de contacto con el testigo.
Good luck, sir.
Buena suerte, señor.
Please tell me your name.
Señor, por favor, dígame su nombre.
Manuel Sánchez.
Manuel Sánchez.
21 CF 14282, you're here charged with aggravated battery.
El caso número 21 CF 14282 se le acusa de agresión física agravada.
There is probable cause.
Existen indicios de criminalidad.
I'll appoint an attorney to represent you.
Se designa el abogado de oficio para que les represente.
Your bond is $10,000.
La fianza son $10,000.
You can have no contact with a victim or witness in this case.
Se le prohíbe todo tipo de contacto con la víctima y o testigos de este caso.
You can't possess a weapon, firearm, or ammunition.
Se le prohíbe la tenencia de todo tipo de armas, armas de fuego y municiones.
You can't return to the scene for any reason.
Se le prohíbe regresar a la escena del ilícito.
Are there any other conditions the state would request?
¿La fiscalía desea solicitar alguna otra condición?
No, Your Honor.
No, su señoría.
Good luck, sir.
I do believe the address.
Buena suerte, señor.
Just wait a minute.
I do believe the address
Señor,
of
un
the
momento.
incident is the same address that the defendant and the victim gave to law enforcement. So I don't know if a separate residence, one-time return may be more appropriate if the defendant has items there.
Su señoría, creo que la dirección que dio el coacusado y la víctima coinciden, así que quizás sea más adecuado permitirles regresar en una ocasión a recoger sus pertenencias.
All right, sir. What I will order is that you must maintain a separate residence from the victim.
Señor, lo que voy a ordenar es que se le prohíbe la convivencia con la víctima.
And I'll allow a one-time return with law enforcement to gather your belongings.
Y se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
But you can't coordinate that with the victim or the witness.
Pero eso no lo puede coordinar ni con la víctima ni con el testigo.
Do you understand?
¿Se lo entiende?
All right, good luck, sir.
Muy bien, buena suerte, señor.
Sir, please tell me your name.
Señor, por favor, dígame su nombre.
Brian Polanco Jiménez.
¿Cómo?
Brian Polanco.
Repítalo una vez más, por favor.
Brian Polanco.
I'm sorry, Your Honor, I can understand his first name. His last name is Blanco.
Brian
Brian Blanco.
Polanco.
Polanco.
Brian Polanco.
Is it Enrique Polanco?
Enrique Polanco.
Brian Polanco.
Ray Polanco.
Enrique Polanco.
Okay.
Enrique Polanco.
Sí.
All right, hold on one moment. Sir, you're here in 21 MM 7781, charged with trespass.
Señor, usted se encuentra aquí ante el caso 2021 MM 7781. Se le acusa de entrada ilícita.
There is probable cause.
Existen indicios de criminalidad.
I'll appoint an attorney to represent you.
Se designa el abogado de oficio para que les represente.
Your bond in this case is $500.
La fianza en este caso son $500.
You cannot return to 455 North Garland Avenue. Do you understand?
Se le prohíbe regresar al 455 North Garland Avenue. ¿Eso lo entiende?
Ujú. Pero es que yo estaba lo que estaba era durmiendo. Yo me monté en una guagua en otro sitio y después me quedé durmiendo y cuando llegué al central, pues el mismo chofer me dijo, mira, despiértate. Y cuando salí me di cuenta que yo estaba en el sitio donde supone que no estuviera. Y cuando de repente viene el guardia...
Señor, permítame interpretar. Well, I was only sleeping there. You see, I was on a bus and I fell asleep. And when we got to the central station, the driver woke me up. And then I was sleeping in the place where I wasn't supposed to be.
No, uno que está durmiendo en el sitio donde no supone, sino que cuando estaba durmiendo en el bus, cuando me desperté, cuando el chofer me despertó, salí para afuera, porque no podía ir para ningún lado, porque tenía que estar ahí, porque la guagua no iba a llevar para otro lado. Pues,
Ok, señor, permítame interpretar, señor. Well, I wasn't sleeping where I wasn't supposed to. I was sleeping on the bus, and then the driver woke me up, and then I stepped outside, but I had to stay there because there wasn't another bus. I had nowhere left to go.
All right, I understand, sir, but at this time, there is probable cause to believe you committed the offense of trespass.
Pero,
Eso lo entiendo, señor, pero en este momento existen indicios de criminalidad para pensar
no era
que
que yo
usted
quería
cometió
ir
el
para
ilícito
allá.
de entrada ilícita.
No era que yo quería ir para allá. Yo cogí la guagua para quedarme antes de la central. Pero me quedé dormido. Y cuando me desperté, ya estaba allá adentro. Y cuando ya el tipo me despierta, pues, ¿qué puedo hacer? No puedo decirle al chofer, mira, llévame para otro lado para no estar aquí. Pues tuve que salir para afuera
Señor, permítame interpretar. Señor, permítame interpretar. It wasn't that I wanted to go there. It's just that I fell asleep on the bus, and when I woke up, we were already there. When the driver woke me up, I was already there, and I couldn't ask him to drive me somewhere else, so I had to stay there.
Sir, I understand what you're saying, but at this time, there is probable cause to believe you committed the crime of trespass.
Señor, yo entiendo lo que usted me dice, pero en este momento existen indicios de criminalidad para pensar que usted cometió el ilícito de entrada ilícita.
If you think you have some defenses to this charge, you're going to want to call your attorney right away.
Si usted considera que tiene alguna defensa para esta acusación, deberá llamar a su abogado inmediatamente.
Your attorney can raise those defenses to the state of Florida.
Su abogado podrá presentar esas defensas a la fiscalía.
Aquí abajo me dieron.
And I'm revoking your bond and you're out on bond case, sir.
Y se revoca la fianza en el caso en el cual se encuentra usted libre bajo fianza.
Call your attorney right away.
Llame a su abogado inmediatamente.
Good luck.
Buena suerte.
Is that it for Spanish speakers? Can you hear what he's saying, Madam Interpreter?
No, he said out on bond, and then I couldn't hear the last thing he said.
Okay, all right. Thank you. I believe that's all we have for the interpreter at this time.
Thank you, Your Honor.
Good morning, sir. Please tell me your name. One more time.
Jonathan Armstrong.
All right, Mr. Armstrong, you're here in 21 CF 14292, charged with robbery armed with a deadly weapon. I'm going to appoint an attorney to represent you at this time. Does the state wish to be heard?
Yes, Your Honor, given that this is a first-degree felony that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing.
Any response, Mr. Brantz?
No argument, Your Honor. He is entitled to that hearing with his attorney, though.
He is. All right, sir. At this time, you'll have no bond on this charge. However, even while in custody, you can have no contact with the victim or any witness. Do you understand?
She can't hear you.
I'm sorry, I can't hear you, sir. Did you say okay? All right. And I'm also going to revoke your out on bond cases, which that actually is good for you because it means you'll be entitled to all the credit time served on all your cases, okay? Call your attorney right away, sir. It's on that green piece of paper. Call that number.
Both cases, Your Honor?
I did. Please tell me your name. Sir, what's your name?
Mitch Care.
All right, Mr. Carey, you're here in 21 CF 14260, charged with criminal mischief, damage greater than $1,000. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me one moment. Hold on, sir. I can't hear you. Get close to the microphone.
Still have a bond?
Yes, you'll have a bond. That's what I'm looking at right now. Sorry, it takes my computer a minute to catch up. Your bond is $1,000. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am. No going there. No talking to the person, to the vet.
You can't possess a weapon, firearm, or ammunition.
Okay.
And I'm hesitant to say not return here. What I'm going to say is, sir, don't go back to this location unless you have an appointment with a physician or you've been court ordered to go there, okay?
Yes, ma'am.
All right. Good luck, sir. Call your attorney right away. Sorry, Miss May.
That's what I was going to recommend, Your Honor.
I didn't want to say don't return there because of what it is and what we have going on, but I wanted to make that clear. Okay. Please tell me your name.
David Martinez.
19 CT 927. Sir, you're here charged with driving while license suspended. It's a second-degree misdemeanor. You're represented by the Office of the Public Defender.
Your Honor, state did convey an offer of an adjudication credit time served.
I did review that offer with Mr. Martinez, but we would just enter a plea of not guilty today, Your Honor.
All right.
Division 82, pretrial conference will be November 22nd, 10:30 a.m., courtroom 10B.
Good luck, sir. Stay in touch with your attorney.
Thank you.
Hold on.
Yes, sir. 21 CT 4622. I'll appoint your office, Mr. Brantz.
We'll waive the appearance. What's the case number again? I'm sorry.
21 CT 4622.
We'll waive the appearance and enter a plea of not guilty.
Division 82, pretrial conference, November 22nd, 10:30 a.m., courtroom 10B.
MM 7680. I'll appoint your office, Mr. Brantz.
We'll waive the appearance and enter a plea of not guilty.
Division 84, pretrial conference, December 13th, 9 a.m., courtroom 4B.
MM 7095. Mr. Brantz, your office already represents him.
We'll waive the appearance and enter a plea of not guilty, Your Honor. It's
Medical.
Coleman'sberger is the last name?
It's Cole Mansberger.
Division 85, pretrial conference is November 15th, 9 a.m., courtroom 4A.
Please tell me your name, sir.
Jose Manuel Perez.
Mr. Perez, you're here in 21 MM 6945, charged with violation of a condition of pretrial release on a domestic violence case. You're represented by the Office of the Public Defender in this charge.
We'll enter a plea of not guilty today, Your Honor.
Division 50, pretrial conference date will be November 22nd, 1:30 PM, courtroom 7C.
Good luck, sir. Please tell me your name.
Omar Ricardo Dennis Williams, Your Honor.
21 MM 746. Sir, you're here charged with trespass in a structure or conveyance and resisting an officer without violence. Let me ask, was there an offer in this case?
Yes, Your Honor. State made an offer of an adjudication, credit time served, no return.
Your Honor, I did convey that offer to Mr. Dennis Williams. I also gave him a plea form to review, and I believe he wishes to resolve today.
All right, I'm going to actually appoint your office in this case, Mr. Brantz, and here's why.
Okay.
Mr. Dennis Williams is out on bond right now on a battery charge, and I would assume that on his behalf, you'll argue asking the court not to revoke that bond, but I'd like him to have a moment to chat with you about that, because even if he enters a plea, at this time, the court has not determined if I'll revoke that bond or not.
Yes,
I want you
Your
to discuss that with
Honor. I
him.
appreciate that. No moment to confer, Your Honor.
Ms. May, while they're discussing, can you pull that case up and tell me if it happened at the same location?
I believe I did, and I believe it did not, but I will
Okay.
double check.
Well, because of what's in the affidavit, I just want to be sure that
Understood.
affects my decision, so that's why I want to know that.
And the out on bond battery, it occurred with the defendant's roommate at the time, back in February. And it was at it was located at Gathering Drive, which I believe is their apartment complex. So it was not at the
Right,
same
so
location.
this OPD case number, there isn't a corresponding clerk case number?
For the battery?
No, this OPD case number that's in the affidavit. It says a disturbance and an assault. And so I just want to make sure if that's an open pending case, I'm aware of it. And I want to be able to discuss that with him as well.
One second.
Okay. Just so you know, Mr. Brantz, I'm sure you reviewed the affidavit, because there's that line in there that says there's an open OPD case for assaulting an employee at the restaurant. That's why I've not made that determination yet, and I want to make sure I have all the information.
I understand, Your Honor. Thank you.
Yes, sir.
I'm seeing that Mr. Dennis Williams has a intimidation, send written threats to commit bodily injury in F2. The victim declined to prosecute that. It was the defendant's mother was the alleged victim in that case. It was
Okay, so that's not this.
not that, and it has a different agency number. But since his name is hyphenated, I need to check our system several different ways, so I'll keep looking, Your Honor.
Okay. All right. Did you have a chance to discuss with your attorney, Mr. Dennis Williams?
Yes, Your Honor.
All right, I'm going to have you raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And Mr. Brantz, has your client made a decision?
I believe he still wishes to resolve. I did go over the possibility that this court may either take no action, set a higher bond, or revoke altogether, and he still understood those possible outcomes. And I believe he still wishes to enter a plea of no contest today, Your Honor.
All right, Mr. Dennis Williams, you heard what your attorney said. Is that what you want to do here today?
Yes, ma'am.
And you had the opportunity to discuss with him the rights you're giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
You understand one of those rights is you're giving up your right to remain silent. You understand that?
Yes, ma'am.
All right. Did you have an opportunity to read the plea form? It further discusses all those rights. Do you have any questions for me about that?
No, Your Honor.
And you understand that if you're on probation anywhere, this plea could violate it?
Yes, ma'am, I understand.
Thank you. And if you're not a U.S. citizen, you could be deported. And if you are not a U.S. citizen, you could be deported.
I understand.
All right, understanding all of those things, sir, at this time, how do you wish to plead a trespass and a structure of conveyance and resisting without violence?
No contest, Your Honor.
All right, sir, I'll accept your pleas. I find they're freely and voluntarily made. I'm going to adjudicate you guilty. And Mr. Dennis Williams, I want to ask you, why did you go back to the McDonald's?
I didn't go back, ma'am. I was walking on the sidewalk. It was a street, so the McDonald's is on a parking lot street also connected. So they said because I was in the parking lot, technically that still counts as trespassing also.
I see.
Just a moment.
So if I order you not to go back to that McDonald's or that parking lot, you'll
I won't go back, Your Honor.
not go back?
Yes, Your Honor.
All right. Go ahead, Mr. Brands.
I take it back, Your Honor.
Okay. All right, sir, I'm going to give you credit for the time that you've been in custody, which is 2 days. I have to order that you pay court costs. Do you have a job?
I was on transitioning to getting one, Your Honor.
I'm sorry, you were what?
I was on the way on to getting one, Your Honor.
Okay, so you don't have one right now?
Not currently.
Okay, I'm gonna give you a year to pay these court costs. I'm gonna order that you can't go back to this location or the parking lot for any reason, you understand?
Yes, Your Honor.
You can't have contact with the witnesses either.
Your
And
Honor,
at this, yes, go ahead.
I did look into that case number. I cannot find anything within our system or on the clerk site that would be associated with that offense number, so I'm not sure.
Okay, thank you. At this time, sir, I'm gonna take no action on your out on bond case. Good luck. You have 30 days to appeal in writing.
Thank you, Your Honor.
What happened with Jason Throckmorton? It's an arraignment case? All right. Mr. Brantz,
Yes,
you have a
yes, sir.
client who was not here. Oh, go ahead. Finish that and then we'll address this.
Thank you, Your Honor.
Thank you, sir.
Mr. Throckmorton, you're talking about, Your Honor?
Yes, 21 MO 931, your office is already appointed. He was medical and not brought here today for his arraignment.
Oh. We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 63, pre-trial conference, November 16th, 1 p.m., courtroom 12C.
Good morning, sir. Can you tell me your name?
Bertram Evans.
You're here in 21 MM 7765, charged with trespass on property after warning. Let me ask, was there an offer in this case?
There was not, Your Honor. He pled on 10/21 to a trespass at the same bus stop. So approximately 10, 12 days ago.
All
The
right.
state did not convey an offer at this time.
All right, Mr. Evans, there is probable cause. I reviewed the affidavit. I'm going to appoint an attorney to represent you. Mr. Brantz, did you want to be heard?
May I have a moment just to speak with him?
Yes.
No, it's an apartment.
That's in Orlando. Your Honor, as to an ROR, I do have an address where he receives mail, if you're so inclined. I may need to update an address with the court. I have an address that he receives mail at. He says an apartment at 1189 South Willow, Orlando, Florida.
Does the state have an objection?
Your Honor, state would just bring your attention to, he does have prior failures to appear. I understand the last one, it looks like was 20, 30 years ago. However, he does have fairly lengthy criminal history, including a recent plea to the same exact offense at the same exact bus stop.
I don't think it's that lengthy.
The state's just concerned about his ability to comply with court orders. If you were to ROR him and him to come back, he was ordered not to return to this bus stop, and then approximately 10, 12 days later, did return. That's why there's a new charge.
All right, Mr. Evans, here's what I'm going to do. I'm going to release you on your own recognizance, like your attorney asked. But you understand that you can't go back to this location. You understand? And if you go back there again and you get arrested again, you can be held at no bond. Do you understand?
Yes, ma'am.
All right. That's the only condition. Good luck, sir. Stay in touch with your attorney. (21 MM 6366). A capias was issued for his arrest. The bond is $500. I'm going to appoint your office, Mr. Brantz. I'll find his refusal a willing waiver of his appearance today. What says the state as to his out on bond?
Your Honor, given that it was just a failure to appear, state would ask that you take no action.
I'll take no action. Good morning, sir. Please tell me your name.
My name is Damon Chenault.
You're here in 21 MO 1265, charged with camping where prohibited.
Yes, ma'am. I didn't know that.
Hold on, don't say anything.
Sorry.
I was pausing to
Your Honor, the
give
state,
the attorneys an opportunity.
the state did convey an offer on behalf of the city of a withhold credit time served.
Your Honor, a moment. I spoke to a few of the city-county ordinances, but not everybody. We were in a flux between moving and in holding and in line to talk to our social services rep. I just need a quick moment, though, if I may.
Can I see the attorneys for a second? Yes, please.
Your Honor, I spoke with Mr. Chenault, and I would request an ROR on this case. I'll give our number as well, so that if there are any services he may be in need of. But it was an instance where he just didn't get to the shelter on time.
Your
All
Honor.
right, hold on one second. I don't know if I appointed your office. Let me appoint your office, Mr. Brands, to represent him, and then go ahead, Ms. May.
Your Honor, respectfully state would object. He did have an ROR, or he did have a failure to appear approximately 4 months ago in June, and a recent plea to another offense in July, as well as he was found in possession of an ID that did not belong to him, as well as a credit card. There are potentially other charges that would be coming. They were just not charged at this point.
All right, thank you. Mr. Chenault, at this time, I am going to release you on your own recognizance. I want to make sure that you understand, however, you have to comply with, you have to come back to court. So you need to stay in touch with your attorney, because if you don't have a place to get mail, the court orders you to come to court and you don't show up, the court can issue a warrant for your arrest and hold you at no bond. Do you understand?
Yes, ma'am.
Do we have an address for him?
I don't know. Mr. Brands, are you getting an address?
Yes, Your Honor.
Okay.
Just a moment.
3802 3828 wait 32802. It's 51 East Jefferson Street. It's general delivery to the post office.
51? Okay.
East Jefferson.
So that's like it. Okay. May I have a change of address slip?
The what? Okay. There you go.
It's supposed to be general.
Okay. May I approach, Your Honor?
Yes, please.
Right. So he does have a PO box that he receives mail, so any correspondence from the court he will be receiving. And then he has our number to stay in contact with his attorney.
All right, sir, you need to stay in touch with your attorney and make sure you appear for court when required. Do you understand?
Yes, ma'am.
Good luck, sir. All right, this is 21 MO 1266. Mr. Brands, do you want to try and reset? He refused, so.
I would reset it. Maybe he'll understand the process better tomorrow. Maybe he's, I don't know. But I would just have you reset it 24 hours.
All right, we'll reset it tomorrow. Sir, please tell me your name. Wait, say that one more time. Thank you. Sorry, I missed it. 21 MO 1267, you're here charged with open container of an alcoholic beverage. There is probable cause.
Your Honor,
Go ahead.
as to probable cause, as I read the affidavit, I don't know if it was clear that Mr. Evans was on public property. I know it gave an address. I couldn't find exactly what location they picked him up at, but they did mention that there was no trespassing sign, so I couldn't tell if he was on private property or public property. I don't know if the ordinance covers any property. My interpretation is only public.
All right, what says the state?
Your Honor, my understanding is a lot of the buildings downtown and on OBT, the businesses do have blanket, like no trespassing signs. It doesn't say, however, he was like in the business or within like a closed curtilage of the business. So my understanding is probably like on the sidewalk. The law enforcement officer does say due to possessing and containing an opened alcoholic beverage on public property within the city limits. But given that there isn't other information and the officer writes it as public property, it would contend that it's public property.
Wait, say that again. State what?
Would contend that it's public property, given the officer wrote that it was on public property. And a lot of businesses have the blanket no trespassing signs in their windows. But the sidewalks and around the businesses tend not to be private property.
Mr. Brandt?
I just didn't interpret it as being on public property like a sidewalk, a road. There were other affidavits I read today that did indicate public property, but this one I felt was lacking in that fact. If you do find probable cause, I did pass the city's offer on to Mr. Evans. I believe he does wish to resolve, but I just wanted to address the court on probable cause before moving forward on that.
All right, so the reason I thought there was probable cause, that's why what I said originally is I was reading this sentence in the third paragraph, but I just realized the name. It says, due to Warall possessing and consuming an opened alcoholic beverage on public property within the city limits of Orlando, he was placed under arrest. So it says public property. However, I just now noticed, who is Warall?
Yeah, I pulled the Google Maps of 18 South Orange Blossom Trail. It is like a sidewalk and then a like strip mall type business. So arguably the parking lot as well as the sidewalk would all be public property that would be dictated by Orange or OPD.
What about the line that I just read? Is anyone else concerned about that?
Yeah, Your Honor, I would agree with you. But then later in the paragraph, it does indicate it's Evans again, so I don't know if it's a Scribner's error or I don't want to.
Is it just a typo?
Since it's the PC statement, officers tend to reuse them and change the name since it's just the title of like the statute and what the statute says. So I believe it was a typo or on the officer's behalf, because in the second line it does say the beverage Evans was consuming. So I believe the officer just forgot to change the name as it was just like the PC statement of the ordinance.
All right, because of that statement, that's why I said there's probable cause, because the officer is actually saying it's on public property.
Yes, Your Honor.
But if you want to ask me to release your client on his own recognizance, I might be willing to do that.
Allow me a moment, yeah. We would request ROR, Your Honor. As to the, I guess, you did find PC, or are you just issuing ROR even if probable cause?
I think there's probable cause because of that statement.
Understood, Your Honor. But we would still request release on recognizance.
All right, sir, I'll grant that request, but you understand that you have to come back for your court dates. If you don't show up for a court date, the judge will issue a warrant for your arrest and can hold you at no bond. Do you understand that? All right, stay in touch with your attorney.
Do we have an address for him?
I don't know. And Sir, you can't possess or consume alcohol while you're out on your own recognizance. You understand? All right. Mr. Brands, get an address, please.
Was Madison or Robinson? All right, I'll take that before, and if we get anything back, on court date. And you can call us too, okay? Call that number, and you say, you should get a letter from us, yeah, with the pin. You give them the pin, you talk to your attorney, or you can come to our office anytime. Downtown by the courthouse. You know where it is? Okay.
Good luck, sir.
God bless you, Your Honor.
Good morning, sir. Please tell me your name.
James Flores.
You're here in 21 MO 1268, charged with disorderly conduct.
Your Honor.
Mr. Flores, do you recognize me? I'm pretty sure I saw you
Yes, ma'am.
maybe a week or two ago
Yes, ma'am.
here at the jail. I'm pretty sure I saw you.
Yes, ma'am.
All right. There is probable cause here, Mr. Brands.
Yes, Your Honor. I did convey the city's offer of withholding credit time served. And I believe Mr. Flores wishes to resolve this case today.
Yes, ma'am.
All right, but Mr. Flores, I think you resolved a disorderly conduct a week or two ago in front of me, just like this.
This will be the last time, Your Honor. I promise.
Your Honor, as
All
to
right,
as to the facts in the affidavit, though, I think it was a food that switched hands.
Right.
So I don't know if it's as disorderly as the statute insists, or as the ordinance insists, but I know we've had this discussion before about
Right.
the intention of the statute.
It's what we have. So, all right, sir, I'm going to need you to raise your right hand.
Swear to tell the truth, whole truth, and nothing but the truth, so help you God.
Yes, ma'am. Help me.
All right, sir, there is probable cause here.
Okay.
And as we discussed, I've seen you before. We've had this discussion before. You understand the rights you're giving up if you enter a plea of guilty or no contest.
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
They haven't changed since you saw me last.
No, ma'am.
But you do understand that if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
And if you're not a U.S. citizen, you could be deported.
Yes, ma'am.
And at some point, Mr. Flores, you might appear in front of a different judge who is not happy about seeing you this many times about this. You know that?
Yes, ma'am. Yes, ma'am.
All right, sir, how do you wish to plead to disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay them. Good luck.
I'm homeless. Yes, ma'am.
You have 30 days to appeal in writing.
You want a number to call us in case you need help?
What?
Okay. You can come by and talk to somebody. All right?
Oh, thank you. Please tell me your name.
Hudson.
All right, sir, you're here in 21 MO 1269, charged with disorderly conduct. There is probable cause. Was there an offer?
Yes, Your Honor, I've been authorized on the state's behalf to offer withhold credit time served.
Your Honor, I did convey that offer to Mr. Hudson. I believe he wishes to resolve today.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, you had an opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
It looks like you were just here 2 or 3 weeks ago for a charge of open container.
Not me.
No, Your Honor, that's a year ago.
Not me.
10,
Oh, 2020. Okay, so that was a long time ago. Okay. Thank you. All right, sir, you understand if you're on probation anywhere, this plea could violate that? If you're not a U.S. citizen, you can be deported? Do you have any questions for me about the rights you're giving up? Did you have a chance to read that plea form that explains those rights to you? All right, sir, how do you wish to plead a disorderly conduct? I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the time you've been in custody.
2 days.
2 days. Sir, I have to order that you pay court costs. I'll give you a year to pay them. Good luck, sir. You have 30 days to appeal in writing.
Okay.
Sorry. Thank you. Please tell me your name.
Jones Wesley Alexander.
21 CO 1374. You're here charged with soliciting without a permit. There is probable cause. Was there an offer?
Yes, Your Honor, it'd be an adjudication, credit time served.
Your Honor, I did speak with Mr. Jones as to the city's offer as well as,
It's a county offer.
I'm sorry,
Adjudication.
county's offer, I'm sorry. And, oh, it's an adjudication of guilt?
Yes.
County case. And he pled to one approximately 2 weeks ago.
Just a moment, Your Honor.
Okay.
Having readdressed the terms of the offer, Your Honor, he still wishes to plead no contest, and he has reviewed a plea form.
All right, please raise your right hand, sir.
Yes, ma'am.
All right, you had an opportunity, you can put your hand down, to discuss with an attorney the rights that you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them? You understand if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
If you're not a U.S. citizen, you could be deported.
Yes, ma'am.
All right, sir, at this time, how do you wish to plead to the charge of soliciting without a permit?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. You understand?
Yes, ma'am.
Good luck, sir. You have 30 days to appeal in writing.
Need a number? Yeah. All right. This is yours.
Thank you. Sir, please tell me your name.
Edward Simmons, ma'am.
You're here in 21 MO 1270, charged with open container of an alcoholic beverage. There is probable cause. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer withhold credit time served.
Yeah. Are these the same facts or
They're
exact same facts as with Mr.
the same location, different narrative. It says it's in an alleyway, which is City of Orlando property.
That's right. Mr. Evans. Just a moment, Your Honor. Second. You have an Your Honor, may I be heard on this?
I'm sorry, what?
Can I be heard on this?
Yes,
Your
please.
Honor? As it's a similar facts or stemming from the same set of facts as Mr. Evans, we did give him the opportunity to be ROR'd and keep up with the court, leave an address with the court in case of any upcoming court dates, and stay in contact with our office. So I spoke with Mr. Sibbons about those same circumstances, and I believe he would also like to request release on his own recognizance. He does get mail at his place of employment. I'm going to have to check to make sure the exact address, but he did give a number and the administrative assistant at that number, and it's called Scale Resource on Sand Lake. I can just go and find an exact address for that location, but would the court consider that bond condition?
I'll consider it. What says the state?
Your Honor, state would object. He's had multiple probation violations as well as parole violations showing an inability to comply with court orders. He's had at least one prior failure to appear. Granted, it was approximately 20 years ago. However, he does also have 30 unknown dispositions, some of which could be failures to appear. He does not seem like a good candidate. He's had multiple municipal ordinance arrests, as well as I told, the probation parole violations. State's concerned that he would be able to comply with the court order and would reappear for court dates.
All right, thank you. At this time, Mr. Simmons, I am going to release you on your own recognizance, but I want to make sure that you understand, if you miss a court date, the judge can issue a warrant for your arrest and hold you at no bond. Do you understand that?
As long as I get my mail at my job, man, I'll be okay.
Okay, and make sure that you stay in touch with your attorney, because, like I said, you can be held at no bond if you miss a court date.
Yeah, that was years ago. I'm 52 years ago.
All right. While you're out, however, you can't possess or consume alcoholic beverages. Good luck.
Does the court need the exact address? I can if you allow me a moment to research it. I was just going to Google the location and see if an address.
Yes, do that right now, and then we'll do the next one, please. Because I want to make sure that the clerk has it. I can't hear you. You should be coming for now. You were all DB cases were this morning. She won't. Who is it? I recognize that name. But DV cases are in the morning, so she's already been seen. What? Yeah, she's already come in. Hold on a second. Yeah. And I didn't revoke her bond in that case because we couldn't figure it out. I saw her this morning. Was that the VOP warrant for her? Can I see that? 2 cases. Okay, hold on a minute. While you're doing that, Mr. Brantz, I'm going to look at something else.
Oh, okay. I was just going to say I might need a little more time because I don't know if I misheard him or.
I don't, she has bond on this case, however, so I'll try to catch her. Yes. Are you? Okay. Let me ask, sir, what's your name?
Byron Fraser.
You're here in 21 CT 934. Capias was issued for your arrest for failing to appear for pretrial conference on a charge of driving while license suspended. The bond authorized is $2,000. I'll appoint an attorney if you don't already have one. But I also see that he has a hold for Polk County, is that right?
Yes, he's sentenced in that county.
He's already been sentenced?
Yes, on a possession of meth case. The end of his sentence is March 29th of 2022.
Okay. All right, good luck, sir.
I've been there since September, and that, like, I haven't gotten any mail or anything about my pretrial anything. I haven't gotten anything.
Hold on, let me pull up I'll tell you when the date was. So if you were in custody when you were ordered to be in court, that's a valid defense. Your attorney will raise that in front of the trial judge. So the capias was issued the 26th of October. So call your attorney right away because they'll be able to prove if you were in custody. That'll be easy to prove. Yes, sir. Okay. Please tell me your name.
Virginia Prendergast.
Ma'am, you're here in 21 CT 1910, charged with driving while license suspended. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't drive without a valid Florida license. Do you understand? All right, good luck, ma'am. Please tell me your name.
Michael Johan Acevedo Cedeño.
21 CF 6506. A capias was issued for your arrest for failing to appear for arraignment on charges of possession of fentanyl and drug paraphernalia. Your bond is $2,000 on count 1, $200 on count 2, and I'll appoint an attorney to represent you. Does he have a hold out of Hillsborough? No. It doesn't say that, it just says open count in case Hillsborough County cases. Okay, good luck, sir. Please tell me your name.
Gary Barnett.
21 CF 3853. A capias was issued for your arrest for failing to appear for a status hearing on charge of possession of cocaine with intent to sell. There's no bond authorized. I'll appoint an attorney to represent you. I'm not going to revoke on the out-on-bond case. Ms. May, does the state wish to be heard on that?
No, Your Honor.
All right, good luck. Please tell me your name.
Right.
21 CF 14251. You're here charged with criminal mischief, damage greater than $1,000. There is probable cause. I'll appoint an attorney to represent you. Hold on one moment. Your bond is $1,000. You can have no contact with the victim or any witness in this case. You can't possess a weapon, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck. Please tell me your name.
Devon Brooks.
21 CF 3373. You're here because a capias was issued for your arrest for failing to appear on charges of possession of utilone and resisting an officer without violence. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Christopher Diaz.
21 CF 14256. You're here charged with fleeing or attempting to elude law enforcement with lights and sirens activated. There is probable cause. I'll appoint an attorney to represent you. Your bond is $15,000. You can't drive without a valid Florida license or have contact with any witnesses or co-defendants in this case. Do you understand?
Yes, ma'am.
Good luck. Please tell me your name.
Going to one Pamela S, ma'am.
21 CF 14272. You're here charged with possession of cocaine with intent to sell or deliver. I'm going to appoint an attorney to represent you in this case. Did you wish to be heard, Mr. Brands?
I mean, my argument always stems from the case of Nelson v. State. I believe a lot of those circumstances are there. However, there wasn't evidence of any transaction. I don't believe any scales were present either. So keeping that in mind, I would argue no PC as to those circumstances. However, it is in the court's discretion.
Ms. May, what says the state?
That case that counsel cited says that weight alone cannot be indicative of possession with intent to sell. In this case, we had 2.3 grams, which is well over personal use. There were small clear plastic baggies in his possession, as well as several $100s. So with the several $100s, the weight, and the small clear plastic baggies, which are indicative of a sale, state with intent that there is probable cause for intent to sell due to there being indicia of sale, i.e. the clear baggies.
And Your Honor, as to my use of Nelson v. State, I use it as, I believe it also includes some guidance. I know weight was the big issue before the court, because I believe they found so many rocks of cocaine, but there was no weight listed. But for probable cause purposes, I use it as guidance.
I understand, and I understand the argument. I anticipated the argument, but I do think the state is right. In this case, there are several other indicia. Now, I don't know what the state will charge, but I think for probable cause, there is sufficient evidence. So at this time, sir, I will find that there is probable cause here. I'll stay the bond at $15,000. You can't have contact with any known drug dealers, and you can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
Thank you, Your Honor.
Yes, sir. Please tell me your name.
Andrew Azebo.
You're here in 21 CF 14199, charged with 3 counts of aggravated assault with a firearm. A warrant was issued for your arrest, so another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Give me one moment. Does the state wish to be heard on bond?
Yes, Your Honor, given the nature of the offense, given that a firearm was involved, I don't see that he has any other history other than potentially some driving offenses. So he does have a limited criminal history, but given that a firearm was involved as well as a child, state would just ask for a reasonable bond on all 3 counts.
Your Honor, he doesn't have any arrests or convictions in Florida or out of state. He would otherwise qualify for pretrial release as well. If you would consider reducing the bond, you would order all by itself, but coupled with pretrial release, a reduced bond.
What says the state?
Your Honor, according to the facts that we have within this warrant, there's arguably 2 aggravated assaults, first with the vehicle and then with the firearm. So state has no objection to you placing him on pretrial release. However, state would still ask for a bond, given there's arguably 2 ag assaults, one with the vehicle and then one with the firearm on all 3 victims.
Including a child.
Including a child.
All right, sir. At this time, I will place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount. Your bond on count 1 will be $10,000. Count 2, actually, all 3 counts, it'll be $10,000 each. With special conditions, you can't possess a weapon of any kind, firearm, or ammunition. I'll order you must surrender this firearm to law enforcement within 24 hours of your release. You can have no contact with any victim or witness in this case. Any other conditions the state would request? I'm going to order that you can't be within 1,000 feet of the victim's residence or place of employment.
I was trying to figure out what this address was, Your Honor, but I'm not sure.
Yeah, I don't know if he lives there or if they live there. I couldn't tell either. So I'm just going to say, don't be within 1,000 feet of the victim's residence or place of employment. You understand? You have to answer out loud.
Yes.
Thank you. Good luck. On the warrant, it also, hold on, sir. It also says no return to the scene. I'm going to say that too, because the judge already ordered it. The other judge ordered it.
No return to the scene?
Right. Good luck, sir. Please tell me your name.
Devontae Francis.
All right, Mr. Francis, you're here for a couple of cases. In 21 CF 14250, you're charged with possession of MDMA with intent to sell, tampering with physical evidence, and possessing or unlawfully possessing, fraudulently or unlawfully possessing identification, and resisting an officer without violence.
Your Honor.
I'm going to appoint an attorney to represent you. Go ahead, Mr. Brands.
As to the facts of the affidavit, I do find PC for attempted tampering with physical evidence, so this is to count 2. That evidence was recovered. It wasn't destroyed or successfully concealed, so I would have you find PC for attempt as opposed to tampering.
What says the state?
State has no objection, Your Honor. It's the same statute, just in addition to 77704.
Is it the hiding the narcotics under his body?
And then I believe clenching the cigarette pack
I
that
see.
had needles in it that then cut the law enforcement officer.
That's how it cut him. Okay. All right. I will find that. It's the same statute. Attempted tampering with evidence. With the addition of, tell me that statute again, Counselor.
777.04. Oh, it's at 03. It might be. I believe it's 04. Let me check.
That sounds right.
It's 04. 77704.
All right, sir. Your bond is $15,000 on count 1. I'll treat the others as subsidiaries. 150 on counts 2 and 3, 100 on count 4. With special conditions, you can have no contact with any co-defendant, witness, or known drug dealer. You can't possess or consume any controlled substance without a valid prescription. In 21 CF 3146, a capias was issued for your arrest for failing to appear for a trial management conference on charges of possession of Utilone, drug paraphernalia, and resisting an officer without violence. There's no bond authorized on that capias, and I'll appoint an attorney to represent you in that case. And then in 21 CF 7821, I'm revoking that bond.
A moment to confer, Your Honor.
All right, and your office is appointed in that case.
Yes, Your Honor. Thank you.
You said 7821 was revoked?
Yes.
Okay, thank you.
Wait. 7821, that's what I have.
That's correct.
'21 CF 7821. Rebecca, is that not right?
2021-7821, yes.
That's what I have as well.
Okay.
Contact.
21 CF 1688. It's a capias counselor. I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right, there's no bond on it.
Understood.
Sir, please tell me your name.
Jonathan Gordon.
21 CF 14249. You're here charged with burglary of a dwelling with assault or battery, and criminal mischief. I'm going to appoint an attorney to represent you in this case. There is probable cause. Does the state wish to be heard?
Yes, Your Honor, given that count 1 is an F1 that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing.
Mr. Brandt, any response?
No argument, Your Honor. He is entitled to that hearing, though.
I will do that, sir. At this time, you'll have no bond on count 1. Your bond on count 2 will be $500. Count 3 will be $500. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, Your Honor.
Even while in custody. Then on counts 2 and 3, also, you cannot possess a weapon of any kind, firearm or ammunition. You cannot return to the Motel 6 for any reason.
Your Honor, I believe he also was residing there in a different unit. So if you're going to do a no return, so it would ask for at least a one-time return for him to go to obtain belongings.
I'll do that. So no return except for one time with law enforcement. I'm not saying separate residence because it's not that kind. Good luck, sir. Please tell me your name.
Angelo Jose Gulan.
You're here in 21 CF 14267, charged with battery on a law enforcement officer and resisting an officer without violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me one moment. All right, sir. Your bond is $2,500 on count 1, $500 on count 2. With special conditions, you can have no contact with any victim, witness, or co-defendant in this case. You can't possess a weapon of any kind, firearm, or ammunition. You cannot return to the American Plaza at 2153 Americana Boulevard. Do you understand that?
Yes, Your Honor.
Are there any other conditions the state would request?
No, Your Honor.
All right, at this time, I'm revoking your bond in 21 CF 9267. Good luck, sir. I was gonna say bonded. All right, that's 21 CF 14288. I'll find his refusal a willing waiver of his appearance today. Mr. Brandt, I'm going to appoint your office in this case.
Yes, Your Honor.
Does the state wish to be heard on count 1?
Yes, Your Honor, given that count 1 is a first-degree felony that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing at a later time.
Any response, Mr. Brandt?
No argument. He is entitled to that Arthur hearing.
All right, I will do that. He'll have no bond on count 1, $5,000 on count 2, $100 on count 3. No contact with any victim, witness, or co-defendant. No return to the scene. Can't possess or consume any controlled substance without a valid prescription. And at this time, I'm revoking his bond in 21 CF 13521. Please tell me your name. Sir, you're here in 21 CF 13556. A capias was issued for your arrest, and then the state filed an information charging you with criminal mischief with damage greater than $1,000. I'm going to appoint an attorney to represent you in this case. Your bond is $1,000. You can have no contact with any victim or witness in this case. You can't return to the scene. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name.
Record Jackson.
All right, sir, you're here in 21 CF 14293, charged with trafficking in methamphetamines greater than 200 grams with a weapon. Hold on. Trafficking in fentanyl, 4 grams or more, possession of heroin with a weapon, trafficking in flunitrazepam, greater than 14 grams with a firearm, trafficking in cocaine, greater than 28 grams with a firearm, possession of cannabis less than 20 grams, and possession of drug paraphernalia. At this time, I'm going to appoint an attorney to represent you in this case. Mr. Brands, before we get to Ms. May, did you have any argument?
Not at this time, Your Honor, no.
I agree with that. I read the affidavit, but I just wanted to give you the opportunity. Yes, Ms. May?
I appreciate it.
Given that count 1 and count 5 are both life offenses, state's asking you to hold them no bond, pending an Arthur hearing on 1 and 5, and set reasonable bonds as to count 2, 3, 4, 6, and 7.
Mr. Brands?
No argument, Your Honor, pending that Arthur hearing.
All right, I will do that. Sir, counts 1 and 5 are first-degree felonies punishable by life in prison, so at this time, you'll have no bond on those. Count 2.
Is an F1?
Thank you. Do you happen to know the bond schedule amount? Well, we don't follow the bond schedule. We sometimes use it for guidance.
For fentanyl, I believe, due to being a high potency narcotic, it's pretty high. 1 second, I can tell you exactly.
Higher than 150?
I believe so.
Okay.
I believe this is the conversation we had with the previous.
It is.
But given it being a high potency narcotic, we likened it to the morphine, opium, oxycodone, hydrocodone, hydromorphine, heroin statute, because at 4 grams, that is also trafficking, and all of the other drugs, it is not. And that statute, 4 grams or more is between 100 and 200. So.
Okay. I had in my head 150, but I wasn't confident I was correct about that. All right, sir. Your bond on count 2 is $150,000. Your bond on count 3 is $50,000. Count 4.
It's also an F1.
The $150,000. 6 is $100. 7 is $100. With special conditions, you can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. And at this time, I'm revoking your bond in 20 CF 13297. Good luck, sir. Please tell me your name. Ma'am, you're here in 21 CF 14255, charged with possession of cocaine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't have any contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Good luck, ma'am.
Your Honor, state would also ask for
Hold on.
no contact with the co-defendant, Richard Salas.
I will order you can have no contact with the co-defendant. Do you understand? Thank you. Thanks, Ms. May. Please tell me your name.
Johnson.
21 CF 14283. Sir, you're here charged with neglect of a child and resisting an officer without violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Does the state wish to be heard on bond?
Your Honor, state would just ask for a reasonable bond, given the nature of the offense. The allegations within the offense seem pretty egregious. However, he is 19 and has little criminal history, all juvenile history, which, as it stands, would still be on his score sheet to date. State would just ask for a reasonable bond, given the nature of the offense and the egregiousness of the allegations within this affidavit.
Mr. Brantz, anything from the defense?
May I have a moment to confer before I respond?
Yes.
Your Honor, as to the state's argument, again, really no history, criminal history other than, I believe, juvenile. And I was a little unclear of who was officially in charge of these children. I believe he and someone else were trying to watch them best they could while I believe the mother was in jail. Although the conditions, according to the arrest affidavit, weren't good at all. For children, I would just have you consider that Mr. Johnson was taking care of the children as he was being helpful, but I was still a little unclear who was really put into charge of the children, if it was more of like a last-ditch effort, kind of just taking care of them, or what.
Your Honor, a brief response to that.
Go ahead.
In the affidavit, it states that Cameron stated the following in a verbal and written sworn statement, that he was Anna's best friend, the mother of the alleged children, and he would watch her kids every day since she started on a hotel work program. He advised that he was using the residents part-time and taking care of them. However, all the witnesses of the other surrounding apartments said that the defendant was the one that they seen at the apartment and who resides with the kids, and they pointed to him and said, that's him. Even if he was residing there part-time and helping take care of the children, the condition that the children were found in, as well as the residence was found in, would not be okay, even if he was watching them part-time. His items were found in the residence. I don't believe the reporter, Ms. Gibson, who allegedly potentially was helping take care of the kids at one point, none of her items were found within the residence. So in regards to the counsel's argument of no one was really sure who was watching the children, there are many witnesses as well as facts that point to that Mr. Johnson was in charge of the children. And even if he was in charge of them part-time, the state of the house and the children is concerning, even if he was watching them part-time.
Yeah, I mean, Mr. Brantz, you and your office and your client might have some really good arguments beyond PC.
Yes, I understand, Your Honor. I think
Because-
I was more so just having the court consider all the circumstances in this particular case to determine bond. I didn't have a probable cause argument.
Right, I understand the arguments, and again, you guys might have some great arguments. I'm not really sure what the state will do beyond this, but Mr. Johnson, I read this affidavit, and I'm disturbed that even you were living in these conditions. So I do think there's probable cause here. Also, because there's 2 children, it could be 2 counts.
Yes, Your Honor.
It's only 1 at this time, but. Sir, your bond is going to be $15,000 on count 1, $100 on count 2. You can't have any unsupervised contact with any minor child under the age of 18. Do you understand that? You have to answer out loud.
I understand.
You must comply with any plan that is set in place by DCF with regards to this or any other situation. You can't have contact with Kia Gibson. What other conditions would the state request? This is an unusual one.
The only thing that potentially would come to mind would be whether he's allowed to return to the residence. I believe at one point within the affidavit, even though it's fairly lengthy, the defendant told law enforcement that he was told by the mother that he was going to be added to the lease.
He did say that.
I don't know if he ever was added to the lease. But given that DCF most likely has taken the children, I don't know if they'd be going back to obtain other items for the children from that residence. The only thing that the state would recommend is potentially a one-time return to that residence to get any of his belongings.
Mr. Brantz?
If the children do end up coming back for items, I believe there would be a DCF officer present, and you have ordered no unsupervised contact, so I believe it would be okay if as long as he and the children aren't there by themselves, he can stay at the apartment as long as the children are in DCF custody. And if they do return, that an officer is sufficient to comply with your order. An officer present, excuse me.
Your Honor, state's just concerned whether he has a legal right to be in said apartment and to
I was just wondering that as well.
tampering with any of the evidence that might be within that apartment.
All right, here's what I'm going to order.
If I may add to that, Your Honor.
Go ahead.
I did speak with Mr. Johnson. He said that he would help out watching the children and stay at the apartment with them. That was kind of the deal.
Well, it says in the affidavit that he stayed there every other night. So if there's not another adult, it means that 2 infants stayed a night alone every other night. This is really a disturbing situation, but here's what I'm going to order. Mr. Johnson, you're allowed to return to this scene one time with law enforcement to gather your belongings and then not again after that. Do you understand?
Understand.
All right, good luck. 21 CF 14277. Mr. Brantz, I'll appoint your office.
We'll waive the appearance, Your Honor.
There is probable cause. Bond is $1,000. No contact with any known drug dealers. Can't possess or consume any controlled substance without a valid prescription. Please tell me your name.
Linus.
You're here in 21 CF 14289, charged with possession of a controlled substance with intent to sell and possession of a firearm and commission of a felony. I'm going to appoint an attorney to represent you in this case.
Yeah, Your Honor.
I need to review this. Go ahead, Mr. Brantz. Did you have an argument? Review this again.
According to the arrest affidavit, there is cash, but as far as the intent to sell, I didn't see. Yeah, it doesn't really go into detail as to how those edible cannabis gummies were packaged, so there weren't multiple baggies. I don't know if you individually even sell edible gummies on the street, if that were the case. I wouldn't have you find probable cause. He may have been in possession of edible gummies. Don't they have their own?
They're individually
statute?
packaged.
But isn't there a statute specifically for like
You're thinking of
THC materials?
The tetrahydrocannabinols, it's for the oils. It's not for the gummies.
I would still not have you find PC as far as intent to sell, but no evidence of a transaction or a scale or any of the circumstances that we usually argue in these kinds of cases. I would just have you find possession, PC for possession.
Ms. May?
Your Honor, first, there doesn't have to be a transaction for intent to sell or deliver. It's the intent to sell, not the actual the transaction. Officer did note that there was a large amount of edible cannabis gummies, which stated 500 milligrams of THC on all of the packages. They are individually packaged, and that's why it says 500 milligrams of THC on each. But in conjunction with a loaded handgun as well as $1,700 in cash, state would contend that that is enough for an intent to sell or deliver, as it wouldn't be in the ordinary course of conduct to have approximately $1,700 in cash and $100 bills wrapped together with a rubber band and a firearm, as well as a large amount of gummies that would be far above personal use amount. If you're otherwise not inclined to find PC, state would ask for 24 hours to get a longer affidavit.
I would still like, Your Honor, I concur with state for a 24-hour, because I'd still like to see a wait on this as well.
There doesn't have to be a wait for this particular charge,
That's true.
but, right, it would be helpful because it says a large amount. Is that 5? Is that 500? Is it 25? We don't know
Gummies are not weighed. It would be, he would tell us how many packages.
how many packages.
It's- they don't weigh them.
That's what I'm saying. What's a large amount?
I'm not sure, Your Honor. State just argues that in conjunction with a loaded handgun and a large amount of money.
Yeah, I think you're right, though, because let's just say it's not cannabis gummies. Let's say it's powder cocaine in these packages or any other drug. If you had a large amount of individually packaged drugs with a gun and this money, I think that would be enough for indicia of intent to sell at the probable cause stage. I think there's probable cause.
May I interject, please?
Sir, you can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
I have pay stub proof of the money, but that's all I had to say.
You have what?
Pay stub proof of my money?
He has bank statements to show where the money came from.
Oh, okay.
Prove my money.
I think that's great and will be very helpful for your attorney. Today, the only thing we're looking at is probable cause and bond. But beyond this, the state's going to have to make a filing decision. So you want to call your attorney right away and tell them that. Because what I'm saying, that's the legal argument we're having here today is there enough information to say there's cause to believe you probably did this? I'm saying yes. Now, that's not the state's burden at trial. The state has to prove this beyond all reasonable doubt. So if you have any defenses or anything else that you think will help your case, you want to tell your attorney about it as soon as possible. I just think that there is probable cause. So your bond on count 1 is $5,000, count 2 is $5,000. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers, and you can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
May we request treating one of the charges as a subsidiary?
Your Honors.
I'm not inclined to do that with weapons charges, counselor.
I
I
understand.
don't typically, and also I'm looking at your client's history, and he has a conviction for possession of cannabis with intent to sell.
Thank you, Your Honor.
Yeah, I'm not inclined to, but thank you. Good luck, sir. Please tell me your name.
Good morning, Your Honor. My name is Marlene Mateo.
21 CF 14280. You're here charged with possession of a controlled substance within 1,000 feet of a place of worship. Hold on one second.
Hold on, I'm just.
With intent to sell.
Your Honor, I'm not sure, just in candor to the court, if it is within 1,000 feet of a place of worship. I don't believe that was alleged by the law enforcement officer.
Right, I didn't see it anywhere in the affidavit.
Yes, Your Honor. Just in full candor to the court, I don't believe that there is PC for that as currently written.
I think you're right. I was going to ask you that because I read the affidavit, both of them, a couple of times, and I thought, I don't see that anywhere. I do think there's probable cause for possession of a controlled substance. Hold on one second. Hold on, I gotta go back to the other probable cause affidavit. Do you have the statute for that, Ms. May?
Yes, Your Honor. For possession of methamphetamine is 893.13 sub 6 sub A.
All right. Thank you. There are other charges that the state could file in this as well. All right, ma'am, your bond on that charge will be $5,000. You can't have contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. In 21 CF 14281, you're here charged with driving while license revoked as a habitual offender. There is also probable cause for that charge. I'll appoint an attorney to represent you in that case as well. Your bond on that is $2,500. You can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
Good luck.
Your Honor, as to the possession charge, don't we usually set it at 1,000 for possession? Since we
I do, Counselor, often, but this case has some different issues.
Aggravating factors.
I'm sorry?
I would argue that there are some aggravating factors for not to be treated as a standard possession due to partially of how it was found.
How it was concealed. Yeah. Good luck.
Thank you.
Good luck. Please tell me your name.
Ricardo Reyes Valdez.
In 2018 CF 17897, a capias was issued for your arrest for failing to appear for court on charges of possession of a controlled substance, possession of cannabis 20 grams or less, and possession of drug paraphernalia. The bond authorized is $2,500 on count 1, $1,000 on counts 2 and 3. I'll appoint an attorney to represent you, and I'll take no action on the out on bond.
I finished that.
Please tell me your name. 20 CF 5143. You're here because a capias was issued for your arrest for failing to appear for arraignment on charges of possession of a controlled substance and possession of drug paraphernalia. There's no bond authorized on that capias. I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Anthony Salguero.
21 CF 14285. You're here charged with possession of amphetamines, possession of a controlled substance, and just that, in that case. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $5,000 on count 1, $1,000 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. In 21 CF 14286, you're charged with driving while license revoked as a habitual offender. There's also probable cause for that charge. I'll appoint an attorney. Your bond is $2,500. You can't drive without a valid Florida license. And it looks like you have a violation of probation out of Manatee County in 21-01253. At this time, you'll have no bond. I'll appoint an attorney to represent you in that case as well, and we'll notify them that you're here. Good luck. Sir, please tell me your, oh, I'll wait. Sir, please tell me your name. Can you hear me? No.
No.
Did you turn it up?
No.
You still can't hear me?
Can't hear you.
What about now?
How about now? No?
I just try to hear you. Just go ahead.
Okay. I'll get as close as I can to the microphone. How's that? Is your name Richard Salas?
Yes.
Sir, I'm going to appoint an attorney to represent you. In 21 CF 14254, you're charged with possession of cocaine. There is probable cause. Your bond is $1,000. You can't have contact with any known drug dealers or with the co-defendant. You can't possess or consume any controlled substance without a valid prescription. Do you understand? Can you not hear me?
You know you said possession of cocaine.
Yes, sir.
Oh.
Mm,
What is she saying?
hold on. Mr. Brantz,
Yes, Your Honor.
do you want to see if you can help him understand what I said?
Yes.
Because since you're here, his advocate is actually here. You can see if you can get through better than I can.
Can you hear me? Okay. Is that better? You got it clear? You're clear? You hear me? Okay. You got a charge, possession of cocaine. And I don't bond in another case, possession of cocaine. You have another case, I don't bond in another case, possession of cocaine. You can give me bond in the current charge? She's gonna give me bond in the current possession? But we don't know what she's gonna do on the bond. On this one. She doesn't know. We don't know yet. So tell us.
Sir?
She'll tell us now.
Yes.
I'm just filling you in, and then she's gonna tell you some more. Giving me term.
No.
She's gonna give you bond on one, and we're gonna see what she does on the second one. Okay.
I'm going to revoke that bond and make it $2,000 with the same conditions.
You got bond on the other one too. It's all together $3,000. $3,000, right?
What do you think? One of them bond for before that remote.
But you said a new bond, $2,000. $1,000,
And this one is another 1,000.
right?
So I got $3,000 bond.
That's right. And you can call us, right? Call us.
Yes, call your attorney.
Okay. We'll get someone to call.
So look, I supposed to have court on December 6th. I guess that was for this one.
You'll still have court.
Still in court.
So now that's not court no more.
No, you
No, there is court.
still have court.
December 6th.
That's right. Downtown, right? Can I get Madam Clerk, if you can, a courtroom number?
That's the auto bond case.
Thank you.
Yeah, sorry, we don't have that one up.
So I need $300.
Talk to a bondsman.
Yeah.
Yeah, they'll tell you what they need. 19D? Thank you.
Yeah, 19D.
That's right.
December 6th.
That's right.
For both of these.
No, for one.
When is this one?
I don't know.
We don't know. Okay, but call us.
Okay.
Good luck. Mr. Brands, you may want to make a note because I want to make sure that I don't know that he heard all those conditions and I don't want him to be violated.
We'll contact him.
Okay, I tried to speak as loudly and clearly as possible, and I know he'll get a copy of it, but I just don't want to run the risk that he doesn't understand it.
Understood. I appreciate it.
Please tell me your name.
Matthew Sanders, good morning.
21 CF, good morning. 6985. Sir, you're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of driving while license revoked as a habitual offender. The bond authorized is $2,000, and I'll appoint an attorney to represent you.
Ma'am, I've been incarcerated since the 8th in Osceola County, and I called the clerk of courts because I had COVID and cleared that with him and wasn't able to, I didn't receive another court date.
This isn't Osceola. Hold on,
That's where I was picked up at, yes, ma'am.
hold on. It's not opening. The capias says that you failed to appear for arraignment on August 26th.
That's the date that I called, or I called that Friday and cleared it with the clerk of courts that I had COVID.
I don't have any notes about that, and this capias was issued by another judge. So what you're gonna have to do is call your attorney right away and tell them you think you have a defense to this failure to appear, because I can't change another judge's capias.
Yes, ma'am. Do you have the judge's name by chance?
Division 20, Judge Wooten.
Yes, Judge Wooten.
Okay, do I have a court date set for?
No, because what happens is if you fail to appear for a court date,
Yes, ma'am.
it's suspended. Your court dates are basically suspended until you get arrested, and then you'll get a new court date. So at this time, I can't tell you when it'll be.
Okay, but from the 8th, does this time count that I've been incarcerated?
You're not entitled to credit for time served, but most judges will probably give it to you.
All right, and if I've already bonded out on this charge before?
That's not relevant to the failure to appear.
Okay.
This is kind of a new charge because you didn't come to court when a court ordered you to. So that's why what you're going to want to do is call your attorney right away.
Yes, ma'am.
Because if you were in custody, that's a defense to not showing up to court.
Yes, ma'am.
Or if you had COVID and were in the hospital, that can be a defense. But they're going to have to get evidence of that and then present it to the judge who signed the capias, who ordered that you be arrested.
Okay.
Good luck.
Thank you, ma'am.
Please tell me your name.
Linda Schoolman Jr.
21 CF 14266. You're here charged with possession of cocaine, drug paraphernalia, and cannabis less than 20 grams. There is probable cause. I'll appoint an attorney to represent you.
Yes, ma'am.
Hold on one moment, sir. Your bond is $1,000 on count 1, $100 on 2 and 3 each. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right, and then in 21 CF 14268, you're here charged with bringing into the state forged bank bills. I'm going to appoint an attorney to represent you in this case as well.
Yes, ma'am.
There is probable cause. Your bond is $1,000. Are there any conditions the state would request in this?
No, Your Honor.
All right. Good luck, sir. Call your attorney right away. Please tell me your name.
Aaron Spates.
21 CF 539. You're here because a capias was issued for your arrest for failing to appear for a status hearing on a charge of lewd and lascivious exhibition in the presence of an employee. At this time, there is no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Kenneth R. Stout, Jr.
Sir, you're here in 21 CF 14257, charged with first-degree murder with a weapon and robbery with a deadly weapon. A warrant was issued for your arrest, so another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard?
Yes, Shauna, given that count 1 is a capital offense and count 2 is a life offense, state's asking that you hold a no bond pending an Arthur hearing downtown.
No argument, Your Honor, pending that Arthur hearing.
Sir, at this time, you'll have no bond on count 1. However, even while in custody, you can have no contact with the victim's family members. Do you understand? On count 2, your bond will be $25,000.
Your Honor, you're setting a bond on a life offense?
Oh, no, I'm not. Thank you. No, it'll be on both counts. You'll have no bond until a bond hearing downtown. But same conditions on both. You can have no contact with the victim's family or any witness in the case. You understand?
Yes, ma'am.
All right, good luck, sir. Thank you, Ms. May. Please tell me your name.
Denitra Willingham.
21 CF. Well, let me start with the CT. 21 CT 5060. A capias was issued for your arrest for failing to appear on a charge of driving while license suspended. The bond authorized on that capias is $500. I'll appoint an attorney to represent you in that case. In 21 CF 8916, you're here charged with burglary of a dwelling with assault or battery. A warrant was issued for your arrest, which means another judge has already found probable cause. I'll appoint an attorney to represent you. Ma'am, did you wish to be heard?
Yes.
All right, raise your right hand, please.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Robin Walker.
Does the state have questions for Ms. Walker?
Good morning, Ms. Walker. What is your relationship to Ms. Willingham?
Girlfriend.
Is there anything else you'd like to tell the court?
Yes.
What?
On the day when this happened, basically when I was mad, the car had came up missing. So when they wrote it up, we thought it was her, but we went and got video footage from the front office and they seen it wasn't her. It was a young man. So he was supposed to, when they threw out the trespass warrant, he was supposed to not do the statement on her taking the thing because we had got video footage. But when she got the traffic thing, somehow this still was up, and nobody haven't contacted me or anything. It was last spoken of, and we last had dealt with it once it had happened, once they took the trespass warrant off, so it wasn't supposed to still be there or in there because we had got video footage and seen who had took the car, and we thought it was her because we was mad at each other at the time, but we seen the video footage from the front office.
All right, thank you, ma'am.
No problem.
Your Honor, the allegations within the warrant don't allege anything regarding a car being stolen. I don't
No,
know if
that's
this
why
is potentially on something different.
I'm trying to reread it again because
Yes, Your Honor.
I'm confused. That's not anywhere in this.
It was a white car was supposed to be in it because when they came, the shovel was at the front door and they thought it was the neighbor's shovel, but when it fell over in front of the door, they thought it was her because my cousin picked up the shovel and they thought she came with the shovel. But then when we was leaving out, the white car, his car was gone. So he wrote it up because we thought it was her. But we went to the front and got video footage. So he wasn't supposed to put it in there. So I guess he didn't put it in there. I don't know. But it wasn't supposed to. We had done spoke to an officer and everything, and this was supposed to be done and dealt with. It wasn't still supposed to be nothing from it because we had cleared everything.
So this charges burglary of a dwelling with assault or battery, It has nothing to do with what you're telling me. I understand, it sounds like this is a backstory of things that happened earlier in the day, but the warrant, the affidavit for the warrant says that Willingham showed up at the apartment, was trespassed, and told to leave. About an hour later, she came back, and Walker's cousin tried to prevent her from entering the residence, at which time Miss Willingham
That's correct.
bit her.
And basically, when she came to get her stuff, the trespass, but he had already been called out to let the trespass warrant up so she could get her things. So it was supposed to be done. When she came, my cousin thought she still wasn't supposed to be there, so he was trying to stop her from coming there to get her things. When she came, I guess it was on the front porch, but he thought the shovel was hers, but it was the neighbor's shovel on the front porch on the door. So they thought it was from her, but it wasn't from her. After all that had came out, the trespass warrant was supposed to be lifted. That's when the thing with the car, so I guess he didn't put it in there. But that's when it was supposed to be a big thing with the car because his car had got taken and we was mad, so we thought it was her. But when we went and got video footage of everything, it wasn't from her, which is why it wasn't supposed to still be there. That all happened at the same time.
So, but the allegation here is that she pushed her way into the residence and bit your cousin.
That's what he said, but then it wasn't true.
Walker then stated Willingham took the shovel she was carrying in her right hand and swung it at her left shoulder. During the physical altercation, Walker's cousin was able to grab a hold of Willingham, causing her to drop the shovel. Then they got into another physical altercation, and she was able to push Willingham out of the apartment and slam the door.
My cousin threw the shovel. It wasn't from her. He thought it was from her, but it was on the ground from the neighbor when they ran through the door. He threw the shovel and I thought it came from her, but he threw the shovel or whatever and I got hit with the shovel, but it wasn't from her when he threw the shovel from off the floor because he thought it came from her when she was coming through the door.
Unfortunately, it still looks like, based on the affidavit, there is probable cause to believe that she committed a burglary of a dwelling with assault and battery. Ma'am, you can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that? I'm going to give you a moment to talk to your attorney first.
Your Honor, may I ask the witness a question?
Yes, go ahead.
Ms. Walker, in the arrest affidavit, it said you and your cousin allegedly were keeping out Miss Willingham. Is that correct?
I'm sorry.
What? Yeah, it's really hard to hear you, Counselor.
Ms. Walker, it says in the arrest affidavit that you and your cousin were trying to keep Miss Willingham out. Is that correct?
Yeah, we did. Because she was trying to.
Can you just say
yes,
yes or no, please?
Oh, yeah. And we tried to keep her out from.
And then the alleged bite occurred within the residence?
No, he didn't get bit. He was just mad. We were just mad. saying stuff. He didn't get bit. The officer even seen like he didn't get bit.
At this time, and please, if you could just respond yes or no, at this time of these events, did you have a lease for this property in your name?
Wait, did I have who?
Did you have a lease for this property in your name?
Oh, yeah.
And does Miss Willingham have a lease on this same property in her name, a separate lease?
No, her name is on the lease. We have same lease.
But both your names are on the lease?
Yeah.
No more questions, Your Honor. However, as to setting bond, as far as witness testimony, if Ms. Willingham's name is on the lease, she is entitled to access to that property. So I'm not arguing PC for the charge, but I am requesting you set bond.
What says the state?
Your Honor, respectfully, we don't have any of that within writing, or that can be addressed by the court today. And given that it's a first-degree felony punishable by life, state's asking for no bond at this time. We don't have the testimony of the other victim and or witness from this case, nor do we have anything proving that Ms. Willingham is on the lease, which would all be at a later time for like a motion to dismiss if this case were ever to be filed on. However, we don't have that before the court today that the court can rely on when setting anything in this case.
Can I say one more thing, please?
Yes, ma'am.
My cousin, he said he don't want to do anything. He don't want to be involved with no police or deal with this. That's why he's not here. He don't want, cause it wasn't that serious. Like he even told the police, like he don't want to come to, he don't want none of this. Like he didn't write no statement, no anything. And I do have proof that her name is on the lease.
And Your Honor, may I respond as well?
Go ahead.
And my argument, and I'm not trying to hold an Arthur hearing either, otherwise I would have produced the lease. However, as to witness testimony, she has been sworn in, and to the question, she did say that Ms. Willingham has a lease at that same property. Just with those circumstances in place, you do have discretion to set a bond on even a charge punishable by life.
When did you add Ms. Willingham to the lease?
When they let the trespass warrant up and she came back, we've been fine ever since. We dealt with everything, like I say. So her name been on the lease for ever since, like, around the trespass warrant was done and she came back home. Like, it's been on there and I have proof.
Do you know when you did that?
Maybe in like, it was like the end of July, like beginning of August. It was like the end of July, beginning of August, kind of like right then and like right when it happened, because they came out and lifted up the trespass warrant and we was at the office, like in front of the office, doing everything.
This allegedly occurred at the end of July.
I know. So here's the problem with what's happening here. Legally, and another judge has already found this, there is probable cause to believe that she committed a burglary with a battery, burglary of a dwelling with a battery. According to the probable cause affidavit, as of July 27th, 2021, Ms. Willingham was not on the lease. And the facts contained in the affidavit are that she doesn't live at the apartment and that she had an hour prior to this been trespassed. So at the time this offense occurred, she did not have a lawful right to be in the residence.
They told me if she had been there over a week or whatever, she technically lived there, whether her name is on the lease or not. The police even told me this. They said that she technically lived there and I can't put her out or do any of this or any of that. And that is why her name ended up being getting put on the list anyway, because they told me it was nothing I can do, being that she had been there for a certain amount of days. So she had been there, her stuff was there, they seen that her stuff was there. It wasn't supposed to be as no burglary or anything anyways, because we seen video footage. That's what I'm saying. It wasn't supposed to be no like dwelling or no burglary. She didn't break in, she didn't take anything, she didn't do any of that. So it wasn't supposed to be there. I don't even know how it got to that because they haven't contacted me or even said that it was that.
So ma'am, in the state of Florida, for the state to prove a burglary, they have to prove that someone entered a dwelling, a residence, a building, or a car when they didn't have the right to be there, and then did it with the intent to commit some kind of crime or did commit a crime. So in this case, the burglary is she entered the apartment when she didn't have a lawful right to be in the apartment. And the crime that she allegedly committed was a battery and or an assault. Both are contained in this affidavit. Because your cousin is the victim of the battery that's contained in this affidavit, and he is not here to testify before the court today. I cannot allow her to have contact with him. And the affidavit is evidence before the court, and it's very different from the information that you're providing here today. I have a law enforcement officer who, in sworn testimony, tells me that an hour before this burglary with a battery occurred, Ms. Willingham was trespassed from the property and told not to return, and then she did return. So at this time, there is probable cause to believe that she did not have a lawful right to be at the apartment.
She was already in the apartment. Sorry, she was already in
Ma'am?
there. They told me it was nothing that I can do.
Ma'am?
She was already there.
I don't know what you're talking about. I can't address what the police officers told you. What I'm telling you is about this case here today. So because of that, there is probable cause to believe that she committed a burglary with a battery or an assault. In this case, it's an and. So it would technically be 2 counts, although that's not what's arrested. Let me ask Ms. May, I just want to make sure I remember this correctly. You're asking the court to hold her at no bond?
Yes, Your Honor. And I have other argument as to that if you are inclined to set a bond.
I'm considering it, so I'd like to hear your argument, please.
Your Honor, in regards to Ms. Willingham's history, she has a 2021 misdemeanor non-arrest BAT DV from March, victim being Ms. Walker. She has a 2021 misdemeanor non-arrest battery petty theft from approximately January, victim being a different victim, Ms. Davis. She has a 2021 misdemeanor non-arrest BAT DV, approximately also from January, victim being Ms. Walker. She has a 2020 misdemeanor non-arrest BAT DV, victim being Ms. Walker. 2020 misdemeanor non-arrest BAT DV, or just battery, victim being a Ms. Flynn. 2020 non-arrest felony, bat by strangulation, victim being Ms. Walker. 2020 misdemeanor BAT DV, victim being Ms. Walker. 2020 misdemeanor BAT DV, victim being again Ms. Walker.
How many is that, counselor?
In total? 1, 2, 3, 4, 5, 6, 7, 8, 9 that I have for 2020 and 2021. And Ms. Walker is the alleged victim of most of them. I believe 2 or 3 were another victim. However, in all of them, Ms. Walker declined to prosecute.
All right.
But just given the criminal history and the several times apparently law enforcement had to go out and there was a report, state would ask for no bonds.
Can I say something?
Not right now, ma'am. Give me a moment.
Your Honor,
All right, Mr. Brandt's response.
With that in mind, I believe and with witness testimony today as to the circumstances within not just the warrant, but within sworn witness testimony as well today, I believe if you do decide to set bond, coupled with a no contact order, that would ease the state's concern of anything flaring up as to any DV incidences. So I would have you consider that.
All right, go ahead, Ms. Walker. What else did you want to tell me?
Something with some of those police reports, like I spoke when I came in, like I filled out the paper. I even told them like sometimes I would over exaggerate and, do the most because I was mad at her. So I did tell them that, which is what they looked at, and that's why we haven't been back in so long, been in trouble. Like we got everything under control. So sometimes, like I did say, some of those I did over exaggerate and I had to come down here and, be at her court dates or whatever for most of those that she was speaking about.
So, ma'am, I understand what you're saying. It sounds to me like this is a pretty volatile, toxic relationship. And I want to make sure that you understand the consequences of both of your actions. Filing a false police report is a crime. So I just want to make sure you know that. And these are serious crimes that are being alleged. This is not a joke. This isn't, a way to resolve a family squabble. I have a police report, I have a warrant, an affidavit with very disturbing facts in it, and a lot of those facts came from you. And it's very different than what you're saying this morning or this afternoon, but I still have to look at those facts and consider those facts. So at this time, ma'am, I'm gonna hold you at no bond, but even while in custody, you can have no contact with either victim in this case. Do you understand what no contact means? You have to answer out loud.
Yes, ma'am.
Your attorney can file a motion in front of the trial judge.
Is Ms. Willingham, is she still entitled to that Arthur hearing? I don't believe I made any motion to have an Arthur hearing today.
I don't believe you did, Counselor, so
Thank you, Your Honor.
it'll obviously be up to that judge, but I would imagine no. You didn't take testimony other than the one witness.
Just for the record, I want to be clear.
Yeah. Good luck, ma'am. Good luck, ma'am. Good afternoon, sir. Please tell me your name.
Farrell Young.
Sir, you're here in 21 CF 13580. A warrant was issued for your arrest because another judge found probable cause that you committed the crime of grand theft. I'm going to appoint an attorney to represent you. Your bond is $1,000. I'll stay that bond. You can have no contact with any victim or witness in this case. You can't return to the scene of the theft. And at this time, I'll take no action on your out on bond case. Good luck, sir.
And that's all it is? Just that charge of $1,000 bond?
Yes, sir.
Okay.
I'm not revoking your other bond.
Oh, okay.
So you still have another pending case. You need to make sure you're in touch with your attorney because you have two cases that I know of at least.
Okay.
So make sure you don't miss court on one of them. You still have two separate cases.
Yeah, because I was at the courthouse when this happened, going to court with a charge, and they arrested.
Oh, you got arrested on the warrant?
At a courthouse, yes, ma'am.
Okay, so that case is still pending. This didn't change it.
Okay, so if I bond out on this, I'm free to go. I can bond out on this and get out today.
Right, he doesn't have any other holds, does he?
No other host.
That's correct, you
Bond
can.
out on this and go today.
Yes,
Okay.
but then you have court dates now on two different cases.
Yes, ma'am.
Okay,
They'll
Good luck.
reset those because of what happened, right?
right.
Okay, all right.
Good luck. Any other business before court is adjourned?
Nothing from the state.
Nothing, Your Honor.
Court is adjourned.